For pronouncement of judgment, item 1, Writ Appeal 330 of 23.
We have set aside the judgment of the learned single judge, but granted liberty to the writ petitioners to invoke Section 18 of the MSME Act and fast track the claim. Claim has to be processed.
Item number 2, CX Appeal 6 of 20.
We have dismissed the appeal and answered the question of law in affirmative.
Adjournment request, if any, from item number 1 to 7. From item number 8 to 22. From item number 23 to 30.
Item 28, my lord. Pollution Control Board has filed affidavit in opposition. We want to file a reply, my lord, today, my lord. So matter may come up in the next week, my lord.
Adjourn 2 weeks.
I beg to mention item number 20.
22,
20.
20.
Yes.
Yes.
In this matter, weeks after 2 weeks. Lordship.
Who is for the other side?
Lordship,
Have you informed the other side?
no, Lordship, we couldn't contact Lordship.
Please inform them. Then
Yes,
come
Lordship,
and-
but I tried to contact. We couldn't contact.
You inform them and then come, they made a request to the road master.
Please, my lord. With the consent of the other side, I beg to mention item number 27, my lord. In this matter,
27.
yes, my
Yeah.
lord. For 2 weeks, my lord. We have just received the report from the Central Institute of Fishery Technology, my lord. We need 2 weeks time to file our affidavit.
That is that fish,
Yes, my lord.
Your
Yes.
Lordship,
Who is the
I'm
other
for the petitioner appearing on behalf of Dr. P. Agarwal.
do you have any
No, Your Lordship.
2 weeks time?
Deep
At the
location.
request of land council for the response.
Please, your lordship. Lordship, I beg to mention item number 26, your lordship. We require some time to file a reply, your lord.
The motion. Was this PI about?
Lordship, regarding awarding of a tender, lordship, for E-classroom, your lordship.
2 weeks, 3 weeks. Yes.
My lord, with the consent of the other side, I beg to mention item number 23.
Yeah. What do you want?
I want an adjournment for today.
Yeah, 4 weeks. Yes.
My lord, I would like to mention, my lord, one matter, my lord. Can you take in on next week, my lord?
Let that, this mentioning be over.
I thought that it is over.
Item 31 to 38.
May I please, Your Lordship? Lordship, in item 31, Your Lordship, I have filed affidavit in reply to the affidavit filed by the other side, Your Lordship. It is not taken with the record, Your Lordship. Lordship, may I pray for listing?
We'll call for it.
I have taken the consent, may I pray on 28, Your Lordship. I have informed the other side, Your Lordship.
28.
Wait, oblige, Your Lordship.
May I please, lordship? I beg to mention item number 37, my lord. With the consent of all the sides, my lord, my senior Mr. R.P. Kagur is unwell today, my lord. Can this matter be,
Hearing matter.
yes, my lord, can it be fixed on some other date, my lord?
It will remain on the board. Pass over for the day.
But if my only prayer is if a date may be please be fixed in the event it is passed over.
Ma'am, it's only pass over.
Well,
Will be listed
well,
in due
obliged.
course within 2-3 days.
With the concern on the other side, I beg to mention item number 36, my lord. Can it be fixed on 2nd of September, my lord?
What's the urgency in 2nd of September? Why?
The outside council will come. Outside council will.
That is, preliminary objection is raised. It appears that preliminary objection is raised. You have to approach the Supreme Court under section 35.
That is their contention, but their contention is that the question involved in the fixing of the flexibility of the.
Yes, that is the only question.
Yes, sir, that is the only question.
So that, as per section 35L and 35G, has to
That
go
is there.
before the Honorable Supreme Court. In fact, the, seslet has relied on a judgment against which also the appeal was filed before the Honorable Supreme Court.
Yes, that is pending.
That has already been withdrawn.
And lordship, what happened, this honorable court also, in another case, which they are relying on that judgment. That this honorable court says that the question of flexibility is there. So appeal will lie to the Supreme Court. Lordship, here I place two judgments. After considering that, lordship,
Judgments, which two judgments?
no, lordship,
There
here,
are so many judgments. There is Bombay High Court full bench judgment, Delhi
High
High
Court,
Court,
Lordship.
this court also
Yes, Lordship.
recently.
but in that case, lordship, the question of law was different.
The question of law, last question of law, you have made, this substantial question of law which you have proposed. That is there only.
No, that is their lordship, but the,
That is only that whether the party is liable to pay the service tax or not. This is what the question of law
that
is.
is already provided in the survey, 2019-94 Act law. That is in explained. Lordship, we consider, if there will approach the Supreme Court, lordship, with the liberty.
Next week.
May I please your lordship? With the consent of the other side, I beg to mention item 35, lordship.
Yeah.
It's, here I need 4 weeks time, lordship. Because I need to get certain details, some more details.
What is this PIL about?
It's about the environmental pollution in Bongaigaon area, lordship.
And also regarding setting up an industry within the industrial area.
Again, I think so we have issued a direction to you whether this, whatever
Yes.
the
Yes, your lordship.
Yes,
concerned factories within the industrial zone or not.
that only with that regard, we need to get some more documents, lordship. We have
That
applied
was passed long back.
Yes, lordship.
More documents, the industrial area is declared.
We
or
had
not,
filed
that is
also
the only
RTI, so
question.
we are awaiting also few, because earlier also we had filed lordship. We need some more time.
Let it be a last chance, your lordship.
8 weeks. Let them.
Oblige, your lordship.
Deeply.
Adjournment request from item number 39 to 50.
Lordship, item number 39 to 44, it's a matter regarding regularization. Some consideration is going on at the government level. Moreover, office bearers have also changed, lordship, short adjournment, lordship, I'll speak.
Get the matters withdrawn. Again, come if the government will not come with the favorable result.
Lordship,
The government is already under consideration. Why to keep these matters pending?
lordship, short adjournment for today, lordship, will speak.
If the government is already considering,
No,
and
not,
grant you the liberty in case if again such situation arises, you may
no,
approach.
no written instruction, lordship, office bearers have changed, therefore, lordship, for today.
10 weeks. Yes,
Lordship, I beg to mention item number 45, Lordship. This matter may kindly be taken after 2 weeks on any date.
why?
My lord, my senior A. Bhattacharya had an operation, my lord. She is on bed rest now. Now, other side is okay.
For the petitioner, madam.
Adjourn,
Obliged.
8 weeks.
Hey, please, your lordship. Lordship, with the prior consent of the other party, your lordship, I beg to mention item number 50 for adjournment, your lordship. The reason is my senior is unwell and not able to appear before this honorable court today, Your Worship.
5-0.
Yeah. 8 weeks.
Any other request?
Yeah, please, Your Lordship. Lordship, I beg to mention this matter, my lord, to be listed, my lord, on 29th of August, my lord. Next
Which,
week.
what's the urgency?
My lord, here, this service matter, my lord, and this honorable single bench allowed my case, my lord, regarding reinstatement service, my lord. And
What is the grievance if your case is allowed there?
since, my lord, the matter is pending since 2019, my lord. And the opposite party filed the writ appeal, my lord, against the order passed by the single bench. And I was for the petitioner, my lord.
Is there any stay?
No,
Then
my lord, here, even then that has not been complied with and it is,
the contempt petition.
no, my lord, I filed the contempt petition as directed by your lordships, my lord. That has been again saying that it is dismissed on limitation ground and saying
It's okay. What to do?
that is the problem now, my lord.
Second week of September. Second week of September.
Lordship,
Second week of September.
lordship.
May it please your lordship. Well, I'm praying for listing of this matter tomorrow for admission, my lord.
Why,
The
what,
urgency is this, my lord, of learned single judge by impugn order. Was pleased to direct the respondents to allot the work in favor of L2, my lord. I was the L1 and my financial bid was rejected. So by tomorrow, the direction was to pass the order by tomorrow, my lord. That is why I'm praying for listing of this matter for consideration.
by the time we'll take up the matter, maybe they'll. do
As
something.
per my instruction, my lord, tomorrow in the second half, they will be going to take the decision, my lord.
Second half, then, are you sure that then your matter will be taken up before second half?
My lord will prior last, my lord. But tomorrow, my lord,
Tomorrow?
deeply obliged.
Maybe, Lordship, I beg to mention one item, my lords, may it be listed on 13th of September, my lords. A matter from Mizoram. My friend from Mizoram requested me to mention this matter. It was fixed, my lord, after it was listed last month, my lords. It was listed, fixed to be,
What's the next date in that?
my lord, there's no date fixed, my lord. That is the issue, my lords. It was to be listed after 4
From the
weeks.
registry, once we have already.
My lord, since what
Once
has
the
happened, my lord, he
date from
comes.
the Registry.
What has happened, my lord, he comes from outstation, my lord. Without an advance notice, it's a difficult for him. And so, I'm praying for
Get
date.
the specific date
Well-
from the registry, whether the registry is denying you to give any specific.
No, we have not approached the registry, my
Then
lords.
you approach the registry,
My lords,
they'll give you
Oh.
the date of your choice.
my lords.
So one, no date is fixed, then certainly they'll give you the date. Approach the date.
Obliged.
May it please your lordship. In this matter, the urgency is that the appellant is not getting his salary, which was previously provincialized. Then later it was set aside by this honorable.
Why it is before the division bench?
My lord,
Why it is listed before the division bench?
it is listed here before on,
The learned single
15,
judge has
7, 20.
rejected your claim.
no,
Then
the opposite party had filed a writ petition due to by the order of which writ petition, the appellant's provincialization was cancelled and he is not getting his salary. So his writ appeal may be heard
the
as soon as possible.
provincialization is cancelled that second week of September.
That's why this writ appeal, my lord. Much obliged.
Daily list for orders, item 1 to 4.
Wait, please, your lordship.
Yes.
Lordship, the order dated 12/10/2023, the corrigendum that was issued by BSNL, that tends to override the judgment passed by this honorable High Court. While the order
Where is that-
dated
where is that
15/6/2017.
earlier
Lordship. Oh, The single bench order is at Lordship page
Single bench order, leave,
20 to 24.
which single bench order, sir?
Lordship.
Not
The
the
division
single
bench
bench
order.
order.
Division bench order, Lordship.
Division bench order we have already seen.
Yes, Lordship.
The division bench order says that as a necessary order, the petitioners could not have been denied the benefits of benefits flowing of the order dated 27/5/99 by which the temporary status of casual laborers scheme conferred on them. On this ground alone, the improved order as well as the judgment set aside and quashed respondent shall now work out the benefits which the petitioner are entitled to the three writ petition allowed no cost.
Lord,
Thereafter, which order they have passed?
Lordship, they have passed a corrigendum. That is, that your Lordship is
Corrigendum, the,
At
corrigendum
page-
is passed in the year 2023.
23,
Prior to
Lordship.
that, which order they have passed?
They have directly passed, prior to that, they have passed the order at, in 28/7/2023 at page 51 to 60 in our additional affidavit, Lordship.
50.
There, they have not changed anything.
Just a minute. You are reading,
At page 51 to 60,
dated, additional affidavit dated,
additional affidavit dated, Lordship. 8 of April 2024.
so, okay.
Order dated
Just a
28/7/2024.
minute,
Change for now. Lordship, clause 3 of 3E.
Let the order be placed before. So, what is that affidavit, 8th of April 2024?
Case number 83 of 2018. Item number. Dated 8 April 2023. 24. Page number 51.
July, certificate of 29th July. After that, note.
Page number, page number 51. No copy to video, no. Brother.
This affidavit was filed in which case?
Lordship, in case number, item number one only. Lordship.
83 or 2018.
Document को या बेलक के दिशा में document Lordship, the document is not annexed here, but it was given separately in the file. The affidavit is here, but the document is kept separately. Lordship. Document is,
Then how we are relying on the document?
document to बेलक के दिया.
Affidavit पण असे
Affidavit कौन আছে? तो annex का तो बेलक के है.
next time I
एक कौन annex है?
Documents is there, not filed.
Affidavit, didn't it? Affidavit.
Malota, as I recollect, these documents were placed prior to filing of the affidavit, and thereafter the affidavit was filed. The affidavit probably did not enclose these documents again.
My item number is there. Item of four, the additional to annex.
अपन आता है ऐसा
Photo,
Item number four, page 72. Page 72.
photo दिखा हो रहे हैं हमारा केस ये बंदा का नहीं
Is this the order dated 26th of August 2083?
18/7/2023 Lordship.
18/7/2023.
27.
Hmm? 28/7.
My additional affidavit is there in that item number four.
Case number 9.
Page number nine.
74.
Additional thing accept, I mean,
Dated.
Additional affidavit of the
I know 22/4/2024.
मेरा क्या
22/4/2024.
reply करना देखिए ऑप्शन.
So you are referring to this clause E,
Clause E Lordship.
this comes clause, the condition number E.
Lordship.
Now what they have changed?
They have changed the word GPF to EPF Lordship.
Where is that?
That is, they brought in by the corrigendum dated 12/10/2023.
It is on page
Page number 61, if it is the annexure. Take on digit.
61. In fact, again,
you are reading.
Yes.
So Lordship, the question here is, Lordship, can a officer of BSNL override the order passed by this Honorable High Court? Lordship?
Well, what is the order of this court?
Order of this court, Lordship, or the
You are entitled for TSM.
TSM, yes,
status
Lordship,
That they have done.
flown
that
out
they
of
have
that
granted.
order of 1996, Lordship.
1996, now if the BSNL was created in the year 2000 for the first time, and if they have decided that all the BSNL employee would get the benefit under the, or could be fitted under the EPF scheme, how exception can be carved out for you people?
Lordship, but we were employees from 1996, Lordship. We are not their employees from 2000, Lordship.
Sir, your absorption in the BSNL is from 2000, 2000 only.
Lordship.
So you are, you have to abide by the,
Lordship, the
whatever the.
Lordship, my humble prayer, Lordship, their absorption may be from 2000, but the TSM scheme was given to them from 1996. Lordship.
This employee of the BSNL is this getting this under the EPF scheme or GPF scheme?
My lord, those people, when this PSU was created, my lord, Rule 37A of the CCS was amended.
Fine.
And accordingly, people who were already in the regular establishment as regular employees, they, my lord, continued to get the benefit of GPF, being employees of the DOT. They are thought to be in deputation in BSNL. And the rest, my lord, all came under the coverage of EPF.
I think that
It's a issue, my lord,
has
that
already been complied with.
But Lordship, they have changed.
If you have any grievance regarding that you are entitled to be this your case is covered under the GPF scheme, then it's a fresh cause of action you may.
Good adjudication, my lord.
Lordship, in
Adjudication
fact,
and
they should
as per
have,
them, this matter is already pending before the Honorable Supreme Court.
Lordship, Supreme Court have already decided our case, Lordship. They have
Your case altogether different, whether the BSNL employee, casual workers regularize in the BSNL will come under the GPF scheme or not. That matter is already pending before the Supreme Court.
When this matter is came before the Supreme Banks, because they silent. And thereafter the Supreme Court, they go to the Supreme Court, they also not say anything. And thereafter, the consent petition was filed, thereafter they complied with by giving the GPF. Now by correndum, they say that they are not.
So what is the willful disobedience?
My lord, yes, definitely, my lord, because of that, they did not say, because of the Honorable High Court, my lord.
We find that this order passed by the division bench is substantially complied with. However, if you are aggrieved by any other action.
My lord, in the year of 1996, there is a scheme, my lord. On the basis of the scheme, my lord, we are given the TSM. And in the meantime, the CBI case was started and thereafter we are acquittal. And thereafter they have to pay, my lord. Therefore, Honorable Division Bench is clearly stated, my lord, to give it the benefit
Can they change only one clause, Lordship, from 1996?
Whatever it may be, rightly or wrongly, they have justified it. If you are aggrieved by that, then you can very well, it's a fresh cause of action you have.
Now, my lord, some of the petitioner is going to retire, my lord, and they are.
Whatever it may be, sir, ultimately they'll
But
get
we
the
are in-
benefit.
we will never
They'll get
make
the
up- we
benefit
have
if
to
the
pay
court
back.
orders in favor of them. They'll get the benefit even though they are retired.
EPF benefit is slightly lesser maybe than ZPF, but then still they have got it.
Yeah.
The EPF benefit might be a little bit lesser, but then they are getting the
If you
EPF.
smell of Employees provident fund, employees deduction as fixed sum from year of the salary every year. Well, they did not do it, my lord, and my lord, division bench clearly stated, my lord, petitioner could have been denied benefit for the out of order.
Yes.
And was conferred on the, on that ground, in order to satisfy and respondent directly give the all benefits.
All benefits. Yeah.
All benefits, you will not sit by the respondent, the authority can now work out the benefit to meet the petitioner as per the, in the scheme of 1996. Well, now they cannot mind of. change the
Lordship, we are
due.
placing reliance on a Supreme Court judgment, Lordship. Can you place it? 2009 8 SCC, Lordship.
Yes.
431. Dada, copy. Paragraph 32, Lordship. May I read, Lordship? Paragraph 32.
Yes.
Yes, Lordship. Before parting with this aspect of the case, we consider it proper to notice the ratio of the judgments on which reliance has been placed by the Learned Council for the Employees. In Madan Mohan Pathak versus Union of India, a 7-judge bench considered the constitutional validity of Life Insurance Corporation Modification of Settlement Act of 1976, by which an attempt was made to nullify the mandamus issued by the Calcutta High Court for payment of bonus to the employees in terms of the settlements. This court declared that the 1976 Act is violative of Article 31(2) of the Constitution, and also held that by simply bringing new legislation, the Parliament could not nullify the mandamus issued by the High Court for payment of cash bonus to the employees in terms of the settlement. Lordship, that was legislation, Lordship. Here, it's an executive body, Lordship, an officer.
These contempt petitions are filed by the petitioners complaining that the respondents have not complied with the direction given by this court wide order dated 15/6/2017 in writ petitions number 229/2016, 2228/2016, and 2058/2016. It is contended that the division bench of this court has directed the respondents to grant them benefits flowing out of the order dated 27/5/1996, by which the temporary status under the casual laborers, temporary status under the inverted commas, casual laborers in bracket grant of temporary status and regularization scheme. It is further directed by the division bench to the respondent BSNL authority that it shall work out the benefits of the petitioners which they are entitled to. Stop. During the pendency of the these contempt petitions, the matter was also went up to Supreme Court. However, after the disposal of the cases before the Honorable Supreme Court, ultimately the BSNL has issued an order dated 27 2023, whereby TSM temporary status, what is the full form?
Temporary status
Mazdoor.
Temporary
Temporary status Mazdoor.
Mazdoor.
temporary status
Mazdoor.
Mazdoor, to grant temporary status Mazdoor, comma, TMS to the petitioners pursuant to the order passed by pursuant to the order dated 15/7/2017 passed by 15/6/2017 passed by the division bench of this court. Full stop. It is noticed that in the order also indicates the terms and conditions on the basis of which the temporary TSM status was granted to the petitioners. And the condition number condition number E provides that after rendering 3 years continuous service on attainment of temporary status, the casual laborers would be treated at par with the temporary grade D employees for the purpose of contribution of GPF, and would also further be eligible for a grant of festival advance / flood advance on the same condition as per applicable to the temporary grade D employees, provided they furnish 2 sureties for permanent government servant of this department, from permanent government servant of this department. Full stop. Later on, wide order dated, later on, wide corrigendum dated 12/10/2023, the order dated 28/7/2023 is modified, and it is provided that inverted commas existing EPF scheme will be continued for these casual laborers who have been granted TSM status. Full stop. Besides, comma, the facility of ESI and gratuity will also be extended to them. Inverted commas close. Learned counsel for the petitioners have submitted that the action of the respondent BSNL of withdrawing the benefit of the GPF scheme from the petitioners would amount to nullifying the order passed by this court dated 15/6/2017, wherein it is specifically whereby it is specifically directed that the petitioners be granted TSM status as per the scheme of 1996. Is contended that as per the scheme of 1996, the petitioners are liable to be, the petitioners are covered under the GPF scheme and not under the EPF scheme. Full stop.
The scheme should be of 89, madam, not 96.
Yeah,
The scheme is of 89, not 96.
95.
89, 1980.
It is mentioned in the order itself.
No,
Order 96.
96.
Sorry, 27/5/1996. Yes.
It is the order of TSM granting them TSM earlier, which was cancelled. That was restored. The scheme, the year is not mentioned. The scheme is of 89.
Acha. क्या लिखा है वर्क
कौन से decide करेंगे?
नहीं, as per the casual labor grant of temporary status and regularization scheme 1996. It is submitted that as per the said scheme, the petitioners are liable to be the cases of the petitioners are covered under the GPF scheme and not under the EPF scheme. Full stop. An additional affidavit is filed on behalf of the respondent BSNL on 27th of June 2024, wherein it is mentioned that the casual laborers who could not be regularized in DOT before 1/10/2000, when the East While One Time Scheme, TSM scheme of 89 was in operation, it is contended that the BSNL was formed on 1/10/2010 and 1/10/2000 and the petitioners are absorbed in the BSNL from the said date only. It is further submitted that as per rule 37A of the CCS pension rules, particularly sub rule 21 to 24, the BSNL is required to devise its own pension scheme and make arrangement for funding and dispersing pensionary benefits. It is contended that the persons who were earlier working in the DOT and continue at the time of creation of the BSNL are only entitled are only covered under the GPF scheme, whereas the persons who were absorbed on 1/10/2000 in the BSNL are entitled for are covered under the EPF scheme. Full stop. It is also submitted that the issue of coverage of GPF of casual workers regularized in BSNL is pending adjudication before the Honorable Supreme Court. Since 2012, and the same has not been decided till date. Full stop. The council has therefore submitted that the order passed by this court on 15/6/2017 has substantially been complied with. Having heard the learned concept of the parties and after going through the affidavit, additional affidavit filed on behalf of the PSNS, we are of the view that the order dated 15/6/2017 passed by this court has substantially been complied with. However, it is made clear that if the petitioners are being aggrieved with the action of the respondents of applying EPF scheme in their cases, they are free to challenge the same by availing appropriate remedy. With these observations, these contempt petitions are disposed of.
Obliged, Lordship. Item number 5.
May I appeal, Lordship? I'm appealing for Karbi Anglong Autonomous Council. Lordship.
You are appealing for?
Karbi Anglong Autonomous Council. Lordship. Lordship, here I'm praying for 4 weeks time to file our affidavit. Lordship. For respondent 4 and 6. Lordship.
You are for Karbi Anglong.
Yes, Karbi Anglong Autonomous Council.
What is the road of Karbi Anglong? The road is to be constructed by the PWD.
Yes, sir.
They have already filed this affidavit that the road is already, construction is already completed.
Yes, they have filed a report, Lordship, but then they have also admitted that there is an obstruction on the road. There is a railway line and then there is no crossing on the railway line, Lordship.
That they are working it out.
Lordship, there is no indication that they're working it out. Lordship.
You just see the affidavit. This affidavit, 31st of May 2024.
Yes, Lordship, this is 25th. Para number 6, Lordship.
Yes, read.
It says that the para number 6, third last line, Lordship, I may read from there. The road
For whole
construction.
para number 6.
Yes, Lordship. That with regard to the statements made in paras number 6 of the petition, the deponent denies that the length was only 13 kilometers approximately from the starting point of the road to the end point. The deponent denies that the authorities have been deceiving the petitioner and the public at large, and the construction has been stopped at the length of 13 kilometers. It is denied that the corrupt practices have been carried on within the department through illegal collusion between the concerned officials and contractors. The road construction was hampered due to non-accessibility from both the ends because of the Borlongfair railway track obstruction at one end. Lordship. Then point number 2, they have said that COVID-19 affect delay in completion, and point number 3, material supply problems due to scarcity of laborers and untimely rain affected the completion time to some extent. However, now the road is completed and the people are using with satisfaction. No final payment has been made till now. The road has been completed up to the complete length of 15.5. Lordship, today itself, I received photographs from there that the road is already in a dilapidated condition, Lordship.
The construction, after construction, if it has been, again, have some problem. So far as regarding this, essentially your challenge that the road is, length of the road is 15.5 55 kilometers where the only constructed up to 13 kilometers.
Yes,
This is
Lordship.
what they-
That was one point, Lordship.
That is the only point, sir.
Lordship, with regard to the railway crossing, that was the second point, Lordship. There are
Where is
several
that? Railway crossing.
railway crossing, Lordship. Bypassing. Lordship, para 7.5 also, para 7.5 of the petition. The petitioner was aggrieved that even after receiving a representation and the complaint, the concern.
The aforesaid court may rule नीति call for the report of the in nature. One number.
There are 22 also, Lordship.
Who's appealing for this public works department? PWD, who is appealing? What's your stand about this? They are saying that they don't, there is obstruction regarding a railway line. Yes.
Completed my license, in para, para 6, my license, it is already mentioned that.
Para 6 of what?
Our affidavit in objection.
Read.
In page 60, my license.
Yes, read.
That we record the statement made in para 6 of the petition of the deponent denies that the length was only 13 kilometers approximately from the starting point of the road to the end. The deponent denies that the authorities have been deceiving the petition and the public at large.
That we have already read, Madam, that you say that this road has been completed up to complete length of 15.55 kilometers. What about this issue raised by them? That there is one side, there is a railway track and there is no passage to go through that railway track. So how the people will use that road? If it is blocked by a railway track, what is the use of construction of that road?
Once possible for the time being, Mr. Tina will appear. Possible for the time being, my lord, sir, Mr. Tina will appear in this matter, my lord, sir.
Then why you started arguing? You are not, have the instructions, why you are appealing? Pass over for the time being.
Item 6 and 7.
Yeah, please, Lord. Also, by invoking policy 21, my lord, notification was issued that contained in page 25. Now, my lord, almost 2 years has now elapsed, but that cases are still pending.
In fact, last occasion we suggested you, suggest some.
My lord,
these
we have
measures.
given, yes, my lord, I've given, my lord.
What are those measures, please? What measures you have suggested?
My lord, copy is there, my lord. The last,
Where is that?
last date, 18/4, I have submitted, my lord, before lord.
18/4. Page number,
My lord, there is separate sheet, my lord.
separate sheet.
Okay.
Yeah.
Again, I am giving, my lord. On last occasion, lordship directed us to make certain suggestion. But this is another copy. my lord. दिन ऐसे ऐसे है गवर्नमेंट दिया कुछ से दिस नहीं
So you think that the High Court has not issued any direction to them for disposal of the pending cases now?
my lord,
Till date, High Court is nothing, doing nothing.
no, my lord, that
It's
is
areas committee and everything, they're doing nothing.
no, right now, my lord, if suppose
These measures you have suggested,
my lord,
you think we are not aware of all these measures, huh?
my thing is that, my lord, if suppose the proper initiative will be taken care of, my lord, obviously, my lord, time frame would be given, my lord, then, my lord, that matter possible to dispose of, my lord.
Do you aware how much these judicial officers are burdened and they
My
are
lord,
not
no
doing
doubt, my lord.
anything?
Absolutely, absolutely, my
They are
lord.
not doing anything.
No, my lord, they are doing, my lord, there is no doubt.
Then
My lord, the persuasion should come from the, my lord, concerned public prosecutor, my lord. They have to place before the learned, my lord, magistrate that the matter required to be, my lord, disposed of.
having heard the learned concept of petitioner admit,
Right.
put up in due course.
My lord.
Item 8.
Item 7.
7. Item 7.
My lord, it was PI regarding rules for giving adjournments. The opposition council was supposed to file an affidavit.
Which PIL?
Number 11 of 2024. It's item number 7, my lord.
Item number 7?
Yes.
Both are admitted. Okay, admitted, both are.
My lord, it was admitted on the 5th of April itself. The opposite party was supposed to file a reply.
Okay, then put up in due course. Already admitted, take, if it is already admitted, put up in due course.
If reply.
Item number 8.
Lordship, this matter relates to that water logging in Guwahati, Lordship. We have compiled the activities done by various departments and we are filing the affidavit today, Lordship.
Today,
Today, Lordship. It is in the process of filing.
so what are the proposed measures and
Measures, there are a lot of measures which are ongoing, Lordship, and one major development is that, Lordship. Last month, there was a tender floated by GMDA to rope in a foreign agency to do the overall drainage system work in Guwahati. And on 21st, the MOU is to be signed with them. We have already finalized one. That team is from Netherlands, Lordship. That is the latest one.
you are filing affidavit today?
Yes, yes, little matter come up on Thursday, Lordship.
Let it be on Wednesday, Miller.
Wednesday.
Actually, Lordship, I am going to Delhi tomorrow. I am coming back on Wednesday. That is,
In that case, my lord, could it be on Tuesday next, Miller? In the meantime, I'll also respond to what the state has filed. Tuesday next, Miller.
Okay, Mr. B. Saikia. Learned Advocate General has submitted that detailed affidavit regarding the measures adopted by the various departments and the future plan to tackle the menace of waterlogging and flooding in the Guwahati is to be filed during the course of the day. So, is this matter on
Tuesday next, Miller.
Tuesday?
27th, Miller. 26th is a holiday.
Lordship. On 27.
My lord, I have a small,
26th is holiday?
yes, my lord, it's
Yeah.
a Monday is holiday.
27.
There's a small prayer, my lord.
Yeah.
After, my lord, this news item was published in the newspaper, some people from some locality has approached me, my lord, as an MI security. So what I have asked them, I said, if you have any suggestion, please give it to us so that I can place before the court. That liberty may be given, my lord.
Sure. That is there.
Yes.
It's so open to everybody
Yes,
give
yes.
their suggestions and what are the grievance. Certainly we'll address all those.
I think, my lord, what my learned friend has said just now, that is the ideal thing. Because, my lord, every year money is being spent, but it's not yielding the desired result.
There must be
Therefore,
some
why not have a
concrete-
holistic view of the
concrete
whole?
plan for that.
Yes, yes.
That is there.
I think that will,
now, Lordship, actually, the whatever were the previous challenges they were made. These are new challenges which are coming up now.
We have to
Yes.
tackle all these.
It's a dynamic
my
situation.
lord, I
Every
think my
day
learned
there
friend
is-
will agree. Otherwise, Guwahati is endowed with the natural drainage. My lord, only thing is, my lord, to streamline those. my lord. As a citizen, I'm saying, not as an officer of this
In
court.
fact, the earlier, whatever the challenges were there, they might have taken some steps for to tackle them. But if the new challenges are there.
New challenges are coming up.
My lord, with the increase in population, increase in activities,
These bordering state activities of the bordering state are also concerned.
Yes, Lordship.
File an
no, but
affidavit.
the task is challenging, my lord. Question is,
No doubt about it.
yes, yes.
No doubt about
Because of the terrain, that nothing else, Lordship. Deeply obliged, Lordship.
it. Is this matter on Tuesday?
Item 9.
Yeah, please, your lordship.
Yes,
Lordship, this incident matter pertains to non-compliance of Honorable Court's order dated 3/5/2023. On previous occasion, Lordship had directed the respondents to submit a compliance report.
Lordship, against this order, passed in the writ appeal and SLP was preferred, but that has been dismissed by the Honorable Supreme Court. And against that order, Lordship, the state government has decided to file a review. And that's
You
going to be filed
go
within
and
a day or
filing
two,
review and again SLP and again review.
Lordship.
Was the order?
Order dated 3/5/23, Lordship.
In view of the special, you already been dismissed against the order which has been not been, no option is left with the, except to comply with the direction in 3 weeks. We have already noted this fact, madam.
Lordship.
You may file review. We are not concerned with that.
Just within a day or two, it is going to be filed, Lordship.
Within a day or
Within a day or two, Lordship,
for what?
for filing of the review, Lordship.
Review,
That is-
we are not supposed to give any permission to you.
Lordship.
You may file whatever it may be. We are concerned with that, or comply with the order. You can't take this excuse that since we are filing a review, therefore will not comply with this order.
Lordship.
Once SLP is filed, there is no option with you.
Please, some
except for
accommodation may be granted,
Nothing
your
doing,
lordship.
madam. Nothing doing. Who is the officer will call him? This can't be the attitude. We already
Lordship,
directed you 3 weeks time to file. Nothing doing.
Lordship may kindly fix the matter tomorrow, Lordship. Mr. Deenath is appearing in this matter, Lordship.
Where is Mr. Deenath?
Lordship, he is not available today. Tomorrow, Lordship.
Then why that another junior to her? She mentioned that pass over for some time. Come with the order, nothing else. Where is the order of the court which is to be complied with?
Lordship, page number 12.
What are the directions? As a consequence, appeal deserves to be accepted, order delivery is a consequence. The speaking order is set aside, is directed those applicants who have been granted benefit of allowance, even though they are drawing the minimum pay scale shall also be afforded the allowances in accordance with the pay scale, the financial shall approve the particular from the date review petition is decided. You have to comply with the order, man. Who is supposed to comply with this order?
Chief Secretary, maybe.
Can't take the excuse, the SLB is dismissed, therefore we are filing review petition. Even though pendency of a
That is the
SLP is no ground, there is no question of any consideration that this, since you are going to file a review, therefore we grant you time, not at all. Who is the authority which is supposed to comply with the order?
Chief Secretary, direction. Direction to Secretary. Order to hand over.
Yes. Which is the authority?
Lordship, the direction was issued to. Such an order to direction to and
Which respondent is supposed to comply with the order? Madam, you are not aware?
Lordship, actually,
You
I
are
am
not
not,
aware?
Lordship, I am not in this matter, Lordship. Mr.
Then why
Deenath,
you are appearing?
Lordship, I am appearing on behalf of Mr. Deenath, Lordship.
Look tomorrow.
Deeply plunged.
Item 10.
No, please, your Lordship.
Who is the respondent number 1?
Lordship, the repetitioner, office note dated 14th of August reveals that the service upon the notice upon the respondent number one is awaited, Lordship.
Respondent number 1, service is not complete.
Yes, Lordship.
Who is the respondent number 1?
He is the read petitioner, Lordship.
Writ petitioner.
Lordship.
Take fresh steps for service of-
Lordship.
As per the office report, notice upon the respondent number 1 has not been served till date. Let fresh steps be. I think so. It was. Let fresh steps be taken for service of notice upon the respondent number 1 within a period of
Lordship, 3 days.
within a period of 3 days. On taking such steps, let notice be issued to the respondent number 1 registered AD. Registered AD. Returnable 4 weeks thereafter.
Of last one.
Item 11.
Abhinay, only. Await, await return of notice of respondent number for two more, 3 more weeks.
Item 12.
May it please, your lordship. In this case, we have filed our personal service affidavit, lordship.
Yeah,
Personal service affidavit. As per honorable court order, we have taken steps to Dusky mode, lordship. And after,
You have already taken.
lordship,
What happened to that notices, those notices?
and contender number 1 and 2 accepted notice on 22/7/2024, lordship. And 3 and 4 accepted on 26/7/2024. And we have filed our affidavit in this regard, lordship.
But this AD cards. On respondent number 1, 2, and 3 of this notice or personally served?
Yes, lordship.
Who has received these notices? Picked up from this, can't identify that these persons to whom the notices have been issued has received that notice.
In paragraph, we write their name, lordship.
Respondent number 1, Narayan Powar.
In paragraph,
Only a signature.
only
Whose
signature, lordship.
signature is this?
We stated in paragraph number 3 in our affidavit, lordship.
The request instantly. Office beyond.
Yes, lordship.
It's a contempt petition. Notice has to be served personally, office beyond, how the office beyond? Tomorrow they'll come and say, I'm not aware that. As per the office report. The AD card bearing signature of the respondent number 4 is already received. The service of notice upon the respondent number 3. Respondent number 4 be treated as complete. So far as regarding the respondent number 1, 2, and 3 are concerned. As per the office report, neither AD cards nor answered notices have been received in respect of the above referred respondents. And it counsel for the petitioner has submitted that the notices of the respondent number 3 has already been served. However, from para number 3 of the affidavit filed on behalf of the petitioner, it is clear that notices have been served upon the office PN and not personally upon the respondent number 1, 2, 3. In such circumstances, we deem it appropriate to await the return of AD cards in respect of service of notice of the respondent number 1 to 3 for 3 more weeks.
And Lordship may kindly allow to take steps to dusty mode again, Lordship.
Let them, madam, in the meantime, if they come, if the notices have come, AD is received, then certainly we'll take note of that.
Okay.
Item 13.
May I please your lordship? My lord, we have already filed our amended cost title.
You have already filed amended cost title.
Yes,
Deccan
my
and
lord.
Council has submitted that. The amended cost titles have already been filed. Office to check, and if the same is filed, let notice be issued to whom the notice will go now.
My lord, respondent number 1.
The respondent number 1. Returnable on so and so.
Obliged, my lord.
Item 14.
Yes, my lord. My lord, I filed in application for correction of your lordship's order, my lord.
Just a minute.
There was some typographical mistake, my lord, in the order. What your lordship had dictated was not properly reflected in the order, my lord. I'm from the link of this.
What's wrong in this order?
My lord, only that, my lord, that the entire case is based on the 1995, my lord, memorandum of settlement, which was also by resolution of assembly. It was also
Sir,
passed
in
in
fact,
case.
The memorandum of understanding of 1st of April 1995.
Yes.
But the memorandum of settlement is of the year 2011 only.
11, but main contentions are in my lord, 1995 memorandum. That's what the
Sir,
case.
here, you just, do you have a copy of writ petition?
My lord?
Writ
Yes.
petition copy?
Yes. Annex A, my lord, case 27.
Could you please come to para 9 of the petition, sir?
Yes. Only that, my lord, years old also were dictated 95. And lastly, in last paragraph, your lord, this is
No, no, sir, we have simply, in the first para also, we have dictated this 2011 only. The PAL petition prayer to issue direction respond and department to not to encroach upon the which was schedule of the Constitution of India and also governed by the memorandum of settlement 2011.
yes.
And we have mentioned this only.
In first paragraph, okay, lordship's order is, my lord. Yes, my lordship will kindly come to paragraph, page 6 of my application.
Yes. 6 of your application.
Yes.
Sir, here, come to the petition, sir.
Yes.
Para number 9.
Yes. Paragraph 9 of the petition is one there, the petition
Page
also.
number 9, para number 17.
Yes.
The 2000, that in 2000 memorandum of settlement was signed amongst the government of India, government of Assam and United People Democratic Solidarity.
Yes.
An organization agitating the greater autonomy of Karbi along autonomous council.
Yes.
In the said tripartite settlement, which was executed in the presence of the Honorable Union Minister, Honorable Chief Minister, transferred altogether 39
Yes.
department of following the provisions of Article so and so, committee schedule so and so, so and so.
Yes.
That in view of the said memorandum of settlement 2000, number of subjects and issues that were fulfilled executed yet to be implemented.
Yes.
That the constraints of this committed so and so, 2, 3 constitute and so on. The commitment of enhancing the number of council out of whatever directly elected so and so has not been given the shape.
Yes.
2.6 was listed, were transferred to the para number 6 schedule, confirming the total number of schedule were transferred, including some of which are already in the 6th schedule listed and so on.
My lord, both the memorandum,
The settlement memorandum is the document on the basis of which you can claim any right. Not a memorandum of understanding, sir.
because memorandum of settlement 1995 has been ratified by the assembly, my lord, and gazetted also. Actually, some departments are increased.
I think so. That would not be serve your purpose, sir. This MOA memorandum of this settlement,
Yes.
2011 is the document on the basis of you can claim any right, sir.
At 95, my lord, what
What
is
we have issued, what we have issued, sir. At this stage, the respondent state and as per the extent of the state, the memorandum of the right and between the state government, KSA and other stakeholders is to be honored
Yes.
until they is not attempted to transgress over the rights of the KSA and allotted subject to the, and in future also the government is bound to honor the conditions laid down in full letter and spirit. What's wrong in that, sir?
Only the word 1995 should also.
The 1995 is only an understanding memorandum of understanding settlement is of 2011. That would serve your purpose. I don't think so that in any requirement for change in the order, sir. Yeah. This This application is filed on behalf of the, this IA number so. Is filed on behalf of the-
2011 is not passed in the cabinet, but 1995 is passed in the cabinet and also
Pass.
passed in the assembly, my lord.
Sir, on the basis of this memorandum of this settlement,
Yes.
2011, those departments have been transferred to you or not?
Yes, sir. And
Transferred.
earlier were 30 departments, 9 departments added.
So ultimately the 95 memorandum is covering only 30 departments, whereas memorandum of understanding is covering, this settlement is covering 39 departments, which is
Hello.
more beneficial for you.
Yes, for the sake, because my lord, for the sake, for my satisfaction and satisfaction. my lord,
Your satisfaction only.
No, that may be my lord, only that qualification, if you lordship, what he was now.
There is no confusion at all, sir.
No, that qualification may be added, my lord, that's all.
Yeah.
That qualification.
So there is no question of any clarification. The order is already clear. Where is the need of any clarification? This IA is filed on behalf of the appellant, on behalf of the applicants with the prayer.
Because lordship dictation, there is a mention like.
Order dated 17/7/2024 passed in PIL number 70/2022.
Because my lord, may I intervene, my lord?
And to replace the figure 2011 with the figure 1995. Full stop. And how this prayer can be maintained, sir? There is no memorandum of settlement of 1995. How
Yes.
can we change this figure in 2011 from 1995?
My lord, your lordship also dictated words. I find somewhere 95 years means. Your
No,
lordship.
we have not dictated.
Yes, my lord, just a minute, my lord. Just a minute. Your
We
lordship
have
kindly,
nowhere dictated.
your lordship kindly see. In paragraph 6, my lord, page 6 of my application.
Yeah.
Yes. In view of the above, submission, the Council for the Union of India has also assured this court that so far as as regarding this act and the actions which are to be undertaken by the Union of India in terms of the memorandum of settlement 2011 and 1995. The process is going on and the central government shall take every possible solution. So,
Mr. Sir, please, in the 1995 MOU, only 30 departments were covered, whereas in MOU 39, this settlement,
there is two, my lord.
39 departments are covered, so which is more beneficial for you?
There is two, my lord, but what I am on is, my lord, what your lordship dictated in page 6, that should come, that's all. That 91, 91. That's all.
We have not dictated anything, sir.
Yes, my lord, your lordship job. In terms of memorandum of settlement, 2011 and 1995.
Filed by the PA respect. Verbatim, sir, this order, you are saying that from where you got this, that we have ordered this from where you got this order, sir?
Also, this court link.
Huh?
This court link is circular, my lord, even everybody sees, my lord, the client quarters on the down. It is live, my lord.
Change that, sir, nothing.
Live it goes, my lord. So nowadays even clients and everybody sees and they said, what is the
Sir, there are many
mention?
things we have to make, many corrections in the orders. After dictating that, that doesn't mean that this order, ultimately the order which is signed is the main order, is the order.
But nowadays, after the link,
Sir, this is,
no, my lord, whatever, after the link goes everywhere, The clients are more aware than we the lawyers.
So now, even though if whatever we say, it should become in the order.
No, not my lord. What we found in your lordship dictation, there is also quoted. Nothing more.
So that
No
is- that
addition,
is
no
nothing-
subtraction.
That is taking undue advantage of this live streaming and nothing else. Ultimately, what we are, the order which we have passed and signed, that is the order of the court. You can't say, since you have said this and why this is not in the order. There are many instances where we have to change orders after dictating it. Many things are
They
there.
are changed, my lord, no doubt.
So you can't take such type of
Anyway,
having heard the non-consent for the applicant, we don't find any reason to grant this. Yeah, the same is there for dismissal.
Item 15.
Yes, you are appealing for?
For the bank. It's only bank.
For the bank?
Yes. For 1 and 2. 1. 1. 1 and 2. No, the matter is fixed for final hearing on 26/8/2000.
In the case of the right of the resolution, bar is guilty for adjournment, Well, we'll dispose it of.
Yes. Malad, I'm taking some time. Malad. My senior is in have some difficulty.
We are disposing it of in terms of this interim order passed by this court.
Malad,
The status quo order which was granted by the DRT is revived.
Malad, I have instruction to take adjournment. Malad, 1 week time may be allowed.
Your lordship, may I please? The matter is fixed before the DRT on 26/8/2024. And the learned DRT has taken note of this honorable court's order. And they have fixed the matter on 26.
26th is not the holiday there.
26/8, yes. Holiday. Then
26/8 is the holiday.
DRT is not, it's not.
DRT is not a-
functional.
Malad, 1 week time may be allowed. My senior.
I think Samnet.
Yes, Malad, I know.
Where is your senior?
Malad, he has some difficulty today. So
Where is he?
he's in Guwahati, but he has some health.
He's in the court?
No, Your Honor, he has
Attending
some,
in some other court.
Malad, he has
So
some
this,
health issues.
this order, we are making this order absolute, which is in your favor.
Yes, Malad, still, Malad, I'm paying for 1 week time, Malad.
Don't you read the brief?
Yes, Malad, I have.
You read the brief?
Yes, yes.
So what's wrong in this order? And if we are making it absolute, how you are going to prejudice?
Yeah, exactly.
How your client is going to prejudice? Please apply your mind.
Yes, ma'am.
No, simply don't say this. Think so your senior would be happy. We are going to dispose it of. You ask your senior that despite your request, they dispose it of. Look here. This writ petition is filed by the petitioner, essentially being agreed with the order dated 8/7/2024 passed by the Debt Recovery Tribunal, Guwahati, in essay number 40/22, comma, IA number 241/22, and IA number 628/2023, whereby the status quo order passed in favor of the petitioner was vacated. This court, wide order dated 12/7/2024, issued notices to the respondent bank and has also stayed the operation of the order dated 8/7/2024 passed by the Debt Recovery Tribunal, while clarifying that the effect of the stay would be that the interim order of status quo granted by the Debt Recovery Tribunal on 20th of September 2023 would stand revived. Full stop. Learned Counsel for the respondent bank has submitted that he has no objection if the interim order passed by this court on 12/7/2024 is made absolute. Full stop. In such circumstances, in view of the above submission made by the learned counsel for the respondent bank, we dispose of this writ petition by making the order dated 12/7/2024 as absolute. Full stop. The writ petition is
Till the matter is taken up by the DRT, because otherwise,
absolute till the matter is finally decided by the deputy.
that would, okay. I know.
Item 16.
Accordingly.
May I please, Your Lordship?
Ordered accordingly, then only ordered accordingly. Yeah,
Lordship, petitioner before Lordship is a permanent resident of
this is
Kashmir.
item number
16.
16, yeah.
Is a permanent resident of the Kashmir town in the conscious citizen, Lordship. There is a pond named Lichu Pukuri, Lordship, having a historical background.
If they have already constructed the boundary
Yes.
to the pond,
The boundaries of the Lordship, we are not disputing a boundary.
then
In the roadside, in the northern side of this Pukuri, there is a Polton Pukuri Road. They now, this is the Kashmir Municipal Board, they have constructed a food counters for the purpose of.
so how you are aggrieved by that? How
Lordship,
you are aggrieved by that?
no, this is, it is for the cause of the public, Lordship. They have
This is the cause of the public.
erected
If
pillars on the,
street, this vending zone is, they have created a vending zone. What's the problem in that?
they have blocked the drain. Over the drain, it has been, it is
So
not.
over the drain, that is, if they, even though if they have blocked the drain, they must be having some mechanism to clear the drainage.
So over the drain, it is
Every
blocked.
time any development project is taken up by any authority and the persons are coming, don't do this, why?
Lordship, they have also erected pillars on the road, on the part of the road, thereby road will be narrowed.
What is the width of the road now? And how it is to be decreased by what?
Exact measurement is not, dear Lordship, but I have a sketch.
Without exact measurement, we are not supposed to look into all these things, sir. Here and there, bald allegation, road would be narrowed and everything is going on. Everywhere, any work, any development work, everybody is checking. What is this, sir?
It will also obstruct the view of this Lichu Pukuri, Lordship.
Which view?
View of the Lichu Pukuri. There is a lychee plantations around this pond.
Is there any?
It will obstruct, Lordship. There is two schools in two sides. There is a temple. It will attract. They are making it a food street, Lordship, making it a food street. And these food counters will attract.
If the local authority is trying to generate revenue by creating some infrastructure, Every time the people will come and don't do this and don't do that. What do you mean? That is, they are best judge for that.
There are two schools
They are
also.
going to narrow the road. How much what is the width of the road? With this construction, how the road is going to be affected? All these things are nothing.
We have annexed the photographs also, Lordship.
You have annexed the photograph. When you approach them, sir?
Lordship,
When you approach them?
on 31/7, Lordship, I have submitted representation.
Representation on 31/7.
7, and these
And
photographs on 25/7.
Within 8 days, you have filed petition here.
No, they are
Not
in full
waited.
swing. Our photographs on 25/7.
7, you have filed a representation on 8th of August, you have filed the petition. So immediately after giving this representation, the petitioner came here in Guwahati and get the PIL prepared and filed that.
Because
So
the
it's
it will be
empty formality and nothing else.
Hey.
You are not serious about this. Let them consider your request or whatever it may be.
They are constructing in
When
full
this
swing.
work
Lordship.
was started,
Park was in 1922, Lordship.
when
It is-
this work of this vending zone or something, when it was
It is in July, in the month of July.
in the month of July, then what you were doing up to whole month?
No, we have Lordship this without his.
Any who owns this lychee orchard?
Lordship,
Who is owning this lychee orchard?
it is municipal board.
It is of the municipal board.
Yes, municipal board has, since 1922, it was developed by the municipal board. There is lychee orchard. The first,
See, this lychee orchard,
yes,
this orchard belongs to whom?
it is developed by the originally municipal board.
Now it is who is
1990.
manning it?
Uh,
Who is manning it?
that most probably the Northeastern Regional Agricultural Marketing Corporation, they have got this GI indication registration of this lychee also. Lordship.
Can be underground also, no? It should can be underground.
I've submitted a sketch map also, Lordship, showing the two schools are in the two sides. There is a Mondi,
How
that
it is
side,
going to be affected? You just tell me, sir.
public will, students and public will be affected, Lordship, because
How? How?
it will attract public crowd.
So
There will be traffic jam.
for the benefit of the public only.
It will create nuisance there, Lordship, because
Since simply because you are saying one person came and said, "Okay, sir, this should not be done. And we should interfere in all this." This is not the,
there will be traffic problem. Apart from that, it will also cause effect.
how much traffic is there on the road? What is the flow of the traffic? How it is going to be affected by narrowing the road? You just give us the details. Give us the details. How many road vehicles are passing in a whole day from this road, sir?
That
And how
details,
it's going to be affected, sir?
exact details is not there, Lordship, but
Then
it is a
details,
busy
we
road.
can't- we
It is a
can't,
busy road.
Basis of this only a submission that it is going to be affected and we are influenced by it. Yes, oh, it's going to be affected. Therefore, the photography, not a single vehicle is there on the road. Not a single vehicle is not on the road. Or in all these photographs, not a single vehicle is there. What type of road it is?
Yes, Lordship.
Not a single vehicle is there.
Yes, so while they are taking photograph, there is no vehicle. There is one or two vehicles are there. The three vehicles are there.
So there is an obstruction in passing of 2 or 3 vehicles in a whole day. And therefore it should be stopped. And when this representation was received by the authorities concerned,
31-7, Lordship.
on 31 itself,
31-7.
where is the endorsement?
Page 81, Lordship.
Page 81, yes. Where is the endorsement?
Yes, in the top, there is seal, and the left side, Lordship, 31-7.
31st of July. Okay. This writ petition is filed by the petitioner in the form of public interest petition with the prayer to issue a direction to the respondent number 3 and 4 to stop the project of transforming Fulton Pukuri Road in the northern boundary of Lichu Pukuri into a food street and construction undertaken in the northern boundary of the Lichu Pukuri over and covering the public drain and erecting pillars on a part of the road and to demolish the same. And it concept for the petitioner has submitted that with the construction of the food street, the road the Fulton Pukri Road would be narrowed down, and on account of that, the free flow of the traffic or the flow on the said road, free flow of the traffic on the said road would be adversely affected. Would stop. Having gone through the PIL petition, we don't find any details regarding the traffic load on the above referred road, and no such material is placed on record. That's how the flow of the traffic is going to be affected by construction of the street zone. Be that as it may, as per the petitioner, a representation raising grievance has already been filed before the district commissioner Sonitpur, Tejpur, Assam. We deem it appropriate that if the said representation filed by the appellant has still not been decided, the district commissioner Sonitpur, Tejpur, Assam shall consider and decide the same expeditiously within a period of 2 weeks from the date of production of certified copy of this order. With my observations, the PIL disposed of.
Item 17.
The Lordship, in this matter, I have not been served the copy of the writ appeal. I am appearing for the writ petition as respondent number 1.
Yes, madam.
Copy not served, Lordship.
Even though if the copy is served, how this order of the learned single judge is wrong?
Wrong, Lordship, the Honorable Single Judge had solely relied on the earlier judgment passed by the
What's wrong in that?
Lordship, because in the
What's wrong
earlier,
in that?
in the earlier order, Lordship, the NOC, which was rejected by the authorities, was under challenge, Lordship, because it was not served to the petitioner at that time.
And on that ground that NOC was not communicated to him, and in the meantime, he has participated in the interview and selection process and got the appointment letter. Lordship. On this ground, in the earlier repetition was allowed. But here, Lordship, the search memo was issued on the ground that there is a policy
Madam,
decision,
Madam, if you
Lordship.
are pressing this petition, then your officer would be in trouble. This frame this memorandum of charges.
Lordship.
What you have mentioned in the memorandum of charges, the officer has presented the same as an evidence before the honorable court, misrepresenting the facts and got a judgment in his favor. So here the persons are getting judgments in their favor by misrepresentation. And the division bench, up to division bench, your case was dismissed. Despite that, you are still acting on the same point. What a judgment means the court is also a party to that in giving that judgment.
No, Lordship.
This is we so. Your officers would be in trouble if you are going to press this petition.
Lordship.
And literally this 50,000 cost is on the lower side.
Lordship, there is a policy decision of the.
Whatever
BRB,
the policy decision, once this NOC issue has been settled by this court up to division bench, you have not challenged that order and that order is attained finality. How can you again issue a charge sheet to that person? On the very same point.
Same point, Lordship, on this, Lordship, on this ground, Lordship.
Okay, then.
Lordship.
Okay, if you chose to argue, argue it.
No, Lordship.
No, if you choose to argue, argue it. Well, certainly the learned single judge was very lenient in that.
Lordship, cost part may be considered, Lordship.
Yeah.
Cost part, Lordship,
No, not at all. Cost part, certainly we are going to increase that cost part, apart from some other observations also regarding the officer who has this framed this memorandum of charges. It's too much. He is being victimized only because he approached this court and nothing else.
Not victimized, Lordship, since there was a policy
Okay,
decision, it was not
if you chose
considered,
to
Lordship.
argue, you may argue it. No problem at all.
No, Lord.
Supply him a copy and argue it out. Ready to bear any other further cost?
No, Lordship, cost part may be.
No, not at all.
was,
Cost
Lordship.
part though we are not going to suffer. No, not at all. If you only one choice is there. If you want to withdraw it, withdraw it. Otherwise, ready for the higher cost and some other observations.
Lordship.
What do you want?
Withdraw, Lordship. I will withdraw.
Yeah.
Yes, Lordship, I will withdraw, Lordship.
Take
Or I will
instructions.
take instruction,
Otherwise
Lordship, it may be taken up at two, Lordship.
Two.
Two, Lordship. God bless you.
Item 18.
Look, before my learned friend starts, I have a small objection with regard to the maintainability of this repetition. Look, I am giving one judgment of another effects for I am relying. Lordship is aware of this position with regard to practice and procedure. Just for my benefit, I am relying on these two judgment, this one judgment. No application seeking clarification from the
What is the order in this?
Lordship, this is not, this will not cover our case, Lordship.
How?
Lordship, this is, the order I'm challenging, Lordship, is order of stay granted by the learned tribunal, Lordship, by which the petitioners transfer orders were stayed, Lordship. Lordship, before, if Lordship gives me some time, I would like to place few facts and regulations, Lordship. If I'm being allowed. Lordship, on the basis of which the stay order was passed was merely on view of another bench's order, Lordship, which is absolutely not correct. And if Lordship allows me to place my case, Lordship, I'll try to satisfy your Lordship.
Yes, yes.
Lordship, before going through the background, Lordship, this regulation. Yes. Lordship, this is the present incumbent, that is the respondent number 1, is in the cadre of personal assistant. And this regulation is in relation to the regulations may be called, Lordship, the flag mark. Employee State Insurance Corporation, Personal Assistant Recruitment Regulations 2008. Lordship, on the next page, Lordship can see where I have highlighted the note 2, personal assistance form and all India cadre. Lordship, meaning thereby that personal assistants have a all India cadre. Lordship, the brief background is, Lordship, on 6/3/24, page number 23, the transfer order was issued. Page 23, Lordship, 6/3/24, it was part of our annual general transfer and along
3/24.
6/3/24, Lordship, page 23. Has the Lordship got it?
Yes.
Yes, that is a part of the annual transfer order, Lordship, along with the petitioners, along with the respondent number 1, there were other 74 incumbents been transferred with that annual general
The
transfer.
name of the respondent number is figured at?
Figured at serial number 45, Lordship, page number 24.
Prakash Sharma.
Prakash Sharma, Lordship.
Yes.
Lordship, he was transferred from RO Regional Office Guwahati to Regional Office Kolkata, and along with him, 74 incumbents were. Then, Lordship, by which this transfer was executed is the transfer policy that is annexed at page number 29.
Yes.
Lordship will see page number 29, the heading, transfer oblique policy in the cadre of personal assistant having all India service liability. And page 30 is clause 4.2, annual general transfer, and subclause 1 says about tenure completion. Lordship, the present incumbent is in the
Annual grade transfer will consider the following categories: tenure completion transfer.
Yes, Lordship, it is tenure completion transfer. Lordship will see the tenure at page number 32, clause 8. Minimum is 3 years, 3 years and maximum.
Considering the transfer request of NC, sorry.
Lordship, only the clause 1. On tenure
All
completion.
postings of personnel shall not honorably be for a period less than 3 years, provided there is a serious complaint, misconduct against the so and so, so and so, so and so. Yeah.
Minimum is 3 years, maximum is in the non-Delhi NCR, it's 7 years. Lordship, and the tenure and page number 29 itself, tenure has been defined.
9 years. Maximum in the Delhi NCR is about 9 years. Establishment shall not be more than 9 years. Not 7 years.
9 years is Delhi NCR and 7 years for other stations, Lordship.
Delhi, whether in the unit
It is-
on the same level. Maximum tenure will be 7 years. Okay.
Lordship will then see at page number at page number 29, tenure has been defined, continuous stay Page number 29, 2.3.
2.3, tenure.
Tenure, Lordship. Continuous stay at a station for a specific period, irrespective of the post or offices within the same station. Irrespective of post or offices, Lordship, within the same. And now this incumbent has been in that, in the present Guwahati RO for about 12 years, Lordship.
12 years.
12 years, Lordship. Lordship, in the meanwhile, after the transfer order, the incumbent moved to the grievance redressal committee as per the transfer policy, but he was not recommended and he was relieved from the Guwahati office on 14/6/2024. Lordship, then this incumbent moved the learned tribunal.
14/6/2024.
Lordship. Lordship, then this present incumbent moved to the learned tribunal by OA 150 of 24. At the first instance, the tribunal did not interfere with the transfer order, but review was filed and then the OA was restored. The impugned order is at page, Lordship.
Just a minute.
Lordship, sorry, Lordship.
Where is that?
Impugned order is at page 142.
Where is the original order?
Original order is, Lordship. Page 128, Lordship. 128 operates from 129.
This is of 21st
Direction.
June, 21st day of June.
Yes, Lordship. Direction was given to file a fresh.
Just a minute, ma'am.
Lordship, Lordship, apologies.
Fine.
Lordship, thereafter, the incumbent filed the review, Lordship. The review order is at page number 133. It starts from 135.
133. Okay, then
Lordship, then the impugned order is page 142,
it is dated.
dated Lordship 28/6/2024. Page 142, Annexure 8.
Yes.
Your Lordship, in the light of the Mumbai bench's order, the impugned order was passed. I've annexed both the petition of the Mumbai bench's OA and also the order. Lordship, that particular OA, which is at page number 148, it was for the, first of all, it was filed by a union, which was for the Maharashtra region. Secondly, Lordship, it was regarding a different transfer policy. If Lordship may come to,
Transfer policy, which different transfer?
Lordship, I'm coming to that, Lordship. Lordship may come to page number 196 of the resolution. One that is part of the OA 477 of the Mumbai bench.
197.
196, that is the resolution, Lordship.
Yes.
Lordship will see resolution, has Lordship got it?
Yes.
Resolution has been passed to file a case in case of transfer posting policy that is within the region up to the cadre of manager. Lordship, that is intra-region. Lordship, the
Therefore, posting policy for regional officer, sub-regional officer, or transfer of non-medical staff within the region up to the cadre of manager, grade, assistant director of PSI corporation.
and Lordship, that particular policy is at page number 184.
184.
Lordship will see the heading. It's within the
Just a
region.
minute. Let us come to that page. Yes.
Lordship will see the heading. It is mentioned within the region, meaning thereby Lordship, it's an intra-region transfer policy, and this particular
Yes.
this particular present incumbent Lordship, he is in the cadre of personal assistant, and his transfer policy is a all India service liability, as I have earlier mentioned, Lordship.
His transfer policy is dated.
Transfer policy, Lordship, transfer policy date is same, but the both are different. Lordship,
Where is
transfer,
that transfer policy?
yes, Lordship, I have annexed the transfer policy is at page 27. Page 29 is the starting part, Lordship, page 29. Transfer posted.
Yes.
Lordship, this is Lordship, I got it. Lordship, now regarding the same issue, Lordship, regarding the transfer policy, already the All India Federation of Union, which is covered now, this present incumbent is also covered under that union, has already filed that OA in the Delhi benches in 2023. Lordship, the Delhi bench was not inclined to pass any stay order in that transfer policy. And subsequently, Lordship, the Delhi High Court also upheld the decision of the Delhi Central Administrative Tribunal's order. And it was also, an SLP was filed by the Federation before the Apex Court, and that was also dismissed, Lordship.
In relation to this very much transfer policy at page 29.
Issue, Lordship, this issue, but which transfer policy is little not very clear in this, but anyways, Lordship, nonetheless, both this Mumbai benches and the present incumbents transfer policy, it's clear that it's different because that is of intra-region, Lordship. And now the present incumbent we are dealing with is of All India Service. There is no, it does not at all cover, just because a parallel policy has been stayed. The coordinate bench of Guwahati bench is was not supposed or ought to have interfered with the transfer orders, Lordship.
Where is the Delhi court's order?
Delhi court's order, Lordship, is at page 257, Lordship. P57, Lordship.
At two.
Lordship.
Item number?
This is the partnership that matter. The date is taken on 25 the Lordship has example to be filed.
Who is for the other side?
Because I give informed him, my lord, then he said that he will survey as my lord.
Yes.
Yes, Lordship. Lordship, in this Delhi's High Court's judgment, Lordship, I would like to read few paragraphs.
Which judgment?
The Lordship was looking into this judgment.
Delhi
I
High
will-
Court judgment.
Yeah, Lordship.
Yeah.
Lordship, page number 58, Lordship, this, the Delhi Tribunal's order has been quoted, paragraph 3, Lordship. Has the Lordship got it?
Page number?
258.
Yes.
The paragraph 3 of the Learned Tribunal's order.
Yes.
Learned counsel for the applicants prays for adjudication on the applicant's prayer for interim relief. There is a stay on the transfer policy. We are not inclined to show any indulgence in the matter. Moreover, he has himself made a statement initially that he would be altering the prayer. Further, putting a restraint on policy is neither advisable nor a correct course of action. It would be putting shackles on the respondents, preventing them from taking routine administrative decisions. Then Lordship, page 260. Has the Lordship got it? Lordship, paragraph 7, last part. It was in these circumstances that the Learned Tribunal proceeded to express its view that it was not advisable or desirable to grant a complete restraint on operation of the transfer policy of the ESI, as it would seriously impact the taking of administrative decisions by the ESI in keeping with the transfer policy. Therefore, paragraph 8, Lordship, we are unable to find any infirmity in this view. As a matter of principle, ordinarily transfer policies cannot be stayed wholesale, even they are challenged. Lordship, now the Mumbai bench's order. Lordship, for Lordship's convenience, I have
Yes.
Lordship, therefore, this Mumbai bench's order, this Delhi High Court's order is prior to the Mumbai bench's order. Lordship, having, we are similarly situated with this Delhi High Court's order, Lordship. And furthermore, Lordship, in order to distinguish the transfer policy that has been stayed by the Mumbai policy, I have formulated a chart for Lordship convenience. Has the Lordship got it?
Yes.
Yes, Lordship will see there are cadres, SSO, manager grade 2, liability, transfer, inter-region, and also infra-region, Lordship. And this is what has been stayed by the Mumbai bench. And Lordship will see in the third column, personal assistant, that is transfer, inter-region, all India basis, no intra-region policy is framed. So this is the transfer policy we are dealing with. This is totally different from the transfer policy that has been stayed by the Mumbai benches. Lordship, therefore, it has, there is no, therefore, in the light of this transfer policy and Mumbai bench's order, the Learned Tribunal would not have passed the transfer or passed the stay order, Lordship. Just because this parallel policy has been stayed, that does not mean that prima facie mean that this particular transfer order is bad. There is no question of there is no question of malafide here, Lordship. It has been, the transfer order has been issued with proper due compliance with the guidelines. Lordship, that is my case, Lordship. And also they have filed a contempt petition which is listed tomorrow, Lordship. And therefore, in light of my submissions, Lordship, I would like to submit that this order of the tribunal may be interfered with.
Yes.
Lordships, first of all, Milord, I have just placed the judgment of the Honorable Supreme Court, Milord, reported in 1999, 6 SSC, page 34. Lord, here, Milord, the Honorable Apex Court was absolutely clear that in a pending proceeding before the tribunal, the writ petition is not maintainable under 226. The reason why is that, Milord? Because two ways, because it amounts to pre-decising the proceeding before the learned tribunal, number one. Number two, we lose one forum. For either of the parties, we lose one forum.
How you don't follow?
Because any decision in this proceeding before your lordship will have the effect in the OA. That is,
Not at all.
it will have the effect on
How can
the,
it be?
if your lordships.
You challenge the transfer policy or your transfer in particular?
Sorry, my lord.
Before the tribunal, you have challenged.
I have challenged the transfer order, my lord.
Order, na?
Yes, my lord.
That we are not, the transfer order is open for the adjudication before the authority. The only question is that they have relied upon
Mumbai bench.
decision or the interim order passed by the Bombay, this Mumbai tribunal
Mumbai tribunal.
in respect of a policy which is altogether different.
That is
from
what
your-
I wanted to clarify to you, lordship. That is what lordship will kindly come to the Mumbai bench order.
Yes,
It's there in the record because lordship has read only one paragraph.
yeah, very bad.
Page 249.
249.
Yes, my lord. I'll take direct, my lord, the paragraph 2, 3, 4 are the submissions. 250, your lordship will kindly come.
250,
Yes, para 6.
yes.
Learned counsel for the respondents submit on instructions that the respondents are contemplating to review the policy of transfer.
Which is that policy?
I'm just coming, my lord. I'll just show what is the difference. He has placed on record office note to that effect. Now, my lord will kindly come to para 12, 251 page.
Yes.
Annexure 1 specifies priority metrics to consider compassionate ground transfer requiring deviation from the norm stroke criteria and tenure prescribed under policy. Annexure 1 is reproduced as under. There are marks given under the different criteria. This clause states that individual cases of transfer posting requests shall be dealt with and decided as per the weightage points secured under priority metrics, and shall cover such cases which are mentioned under the criteria prescribed therein. These cases shall be considered on case-to-case basis on securing weightage points once in every year, with the total number of decided cases restricted to 5% of the total transfer request under 4.21 Roman 1, 4.2 Roman 2, received in respect of a particular post. This clause does not specify as to which group will be preferred and on what basis. A single woman staff, single parent, spouse, ground staff with children exams for the academic year starting in transfer year are allotted 10 points each. If applications are received under each of these categories, how the respondents will decide which case deserves more consideration? We are saying so because each of these categories have been awarded 10 points. In that case, selection would be arbitrary, and as held in the case of EP Roepa versus so-and-so, AI 1974 SCC 555, equality and arbitrariness are the shown enemies. In this view of the matter and having regard to the submissions of learned counsel for the respondents that the policy is under review, we deem it appropriate to stay the impugned policy till the final disposal of the petition and the transfer order passed on the basis of the policy stands stayed in respect of the applicant. Now, this priority matrix that your lordship has seen is same in all the transfer policy.
Whatever it may be, whether this policy is under review, under which you have been transferred.
No, my lord, lordship
is under review or not?
My lord,
under review on what count? Only on this count?
My
that
lord,
these parameters are discriminatory or not self-explanatory.
lordship will kindly see the transfer policy wherein I am transferred.
Sir, what review on what point? They are reviewing on only on this point or any other point?
This priority this priority matrix, they have submitted before the learned tribunal, Mumbai bench, that they are reviewing.
Their statement that they are reviewing this in this policy also.
Milord, can you, Milord, I am just placing one thing, Milord. For the post of manager and SO, there is a priority matrix. For the post of personal secretary also, priority matrix, same priority matrix. So they said that they will review the priority.
That order was passed purely on the basis of this, that as per the submission of the respondent, policies under review, they have stated the policy.
Will it not be discriminatory,
And that
my lord?
This policy under which you have been transferred is under review or not?
Sorry, my lord.
this policy is under review or not?
No,
Is under review or
no,
not?
no, what they are saying is that, we'll review the Mumbai bench's transfer policy, priority metrics, but we'll not review. We'll implement it as it is. That is their stand.
That is,
And one,
you challenge the policy itself.
that is what my stand is. How can your action to be discriminatory? One set of employees, you have issued a transfer policy. You say that
That is to be decided by the, this tribunal.
that is what I'm saying. No, my submission is that if there is a priority matrix which you wanted to review, for one set of employees, you will review, another set we will not review.
Then you challenge this, their action of considering in your transfer policy, this priority matrix. Challenge it before the tribunal.
That's true, Milord. But one more aspect I would like to clarify. So far as, Milord, the distinction sought to be made that Mumbai bench was intra-region.
Yes.
And Milord, this transfer or the petitioner's transfer policy is all India. Milord, Calcutta benches, Calcutta High Court's order, that is also annexed page 254.
Yes.
Lordship will kindly have a look. This person, the transfer order which has been stayed by the Calcutta High Court, relevant portion your Lordship will find page 255.
Yes.
Records reveal, Lordship's government,
Yes.
records reveal the transfer policy on the basis of which the impugn orders of transfer dated 3rd March 2024 and 11 March 2024 have been issued is under review.
Where is that?
All India transfer, Milord.
Where
I'm
is
just
that?
placing. I'm just placing the
Where
order.
is that record? Where is that record, sir? Record reveal, where is that record here?
Here they haven't produced.
You
I'm
produce it.
I'm placing, Milord. This is
This
the order.
All India transfer policy in relation to personal assistant group C is
7
under
March.
review,
Yes,
is under review.
yes, they are saying
Private secretary group B,
all India transfer.
sorry, group C.
Yes,
That is under review.
yes, they have vouched before the Kolkata High Court.
You just show us.
Yes, Milord.
Yes, madam, is it under review? Yes, madam. Is it under
Lordship,
review?
I have
Lordship
no
will-
instruction
Lordship will
as such
kindly
that there
come.
is review.
Lordship will kindly.
Lordship will
Submit your
kindly come to.
instructions. Submit
Lordship,
your instructions.
Lordship, before that, Lordship, I
Page,
would like to,
I'm sorry.
there
Submit
is
your
a confusion regarding this, I think, Lordship.
Submit
These are-
your,
The copy, Didi.
submit your instructions on this point tomorrow.
Lordship,
these,
I,
Transferable region policy
I was
on
wondering
India
after-
basis is under review or not?
Lordship, Lordship,
Is under
Yes,
review
sir.
or not?
Lordship for review matter, therefore I want to show Lordship the transfer, first part, introduction part of the review part. The review regarding that, Lordship, this transfer policy, there was a letter from the Ministry of Labor and Employment, Lordship. The transfer policy page, Lordship will find in third page, Lordship. Third page, Lordship, introduction part. This is the transfer policy that the present incumbent is dealt with.
Third page of what?
Of the transfer policy, Lordship. Third page.
This
Yes, Lordship.
transfer policy, regional
This
office.
is the same transfer policy that I have annexed. Lordship, has your Lordship got it?
Transfer posting policy in the cadre of personal assistant having all India seniority liability. Yes.
Lordship, Lordship will come to the introduction part.
Yes.
Introduction part, Lordship will see presently transfer office of so-and-so personal assistant policy issued by the headquarters 2021. There was a letter from the headquarters from the Ministry of Labor Employment to review the transfer policy of 2020 of that earlier transfer policy. And as per the directions, it has been revised and modified herewith. This is the confusion that is creating about the review, Lordship. As of today, I have that instructions, Lordship.
I'll just,
Otherwise, Lordship,
Whatever the policy, this policy came into force in this revised policy or whatever it may be, revised and modified. This policy came in force in from which date?
Lordship,
This is-
2022,
20th of May 2022.
Lordship.
And this policy is not under review.
Lordship, as per my instruction, it is not under review.
Complete your instructions tomorrow.
Lordship, but tomorrow this, Lordship, this.
My lord, I'm sorry, Mayor. I'm sorry.
Tomorrow. Okay.
My lord, I'll just clarify one aspect of the matter, subject to permission, my lord. If your lordships kindly take up 256 of the writ petition, the transfer order which was stayed by the Kolkata High Court, my lord.
Yes.
Kolkata.
One second. Transfer order number 45/2024, dated 11 March 2024, that is before your lordships, my lord. Thereafter, consequential order was passed not to relieve anybody. That is also before your lordships, my lord. So this, before the Kolkata High Court, there was no challenge to the policy decision, policy of the transfer. But what the Kolkata High Court has, my lord, because there cannot be two standards for two.
We are not concerned with that. The Kolkata High Court records reveal that transfer policy on the basis of the impugned orders have been issued is under review.
Yes.
Let them complete the instruction. If it is under review, certainly your case covers under it. If it is not in review, then we'll consider it.
So that is what my submission is, that if you want to review,
Let them
yes,
clarify.
yes.
Let them
No,
clarify.
that instruction they may take, but prima facie from the fact that they are.
Counsel for the petitioner is directed to clarify that whether the transfer whether the transfer/posting policy in the cadre of personal assistant having all India service liability which is in force from 20th of May 2022 is under review or not. This tomorrow.
Lordship.
No. In fact, my lord, for last 2 months, although there is an stay order passed by the learned tribunal, for last 2 months, my lord, they are not allowing me to join, my lord. I am hanging.
That's, we'll see to it.
Lordship will kindly consider, my lord.
We'll see to it.
Yes.
Tomorrow we'll decide. If it is under review, certainly you have a case. If it is under not in review, then we don't find any.
Well, my contention is that they cannot discriminate between two sets of
Sir, in the
employees.
transfer matters, least interference.
No, this is with regard to policy, my lord. This is not a normal transfer order, hardship and all these things. My lord.
Let us see.
Lordship will consider much of that.
Password meter 5.
But here the allegation is that the road was 15.5 kilometer in the
First of all, Mr. Nath, if you are instructing somebody to make a mention on your behalf, please either ask him or her to have the full instructions and don't come unprepared with what.
I'm sorry, I'm sorry, I'll do that.
Yes,
So here, my lord, we have filed the affidavit that the road is complete and the public is using that road.
that so far as regarding that railway crossing,
But the,
that is his specific issue is that even though if the road is constructed, we would not be able to cross that railway crossing without there being proper arrangement.
but in fact, while filing the petition, my lord, it is a subsequent development, my lord, I have to take the instruction.
Subsequent development, it is only mentioned in the petition itself.
Photos are there. No, my lord, kindly see, my lord, the prayer made in the writ petition is that the quality DPR don't allow the work to be done. But that has been done.
There is a specific.
In paragraph
Just see.
15 and 17, I have seen, my lord, that the and
Now prayer part, prayer, come to the prayer of.
Lord.
Directing the neutral department or agency record how the PUC concerning Aloe at Brahmpur railway station approach road surveyed and prepared, so whatever nature. Directing respondent number 3, so and so New Delhi. Or respondent to take disciplinary action against the official so and so. Directing the respondent to inquire the delay in the project, release of the entire project so and so. Directing the respondent authorities to complete the construction, this relief number 4.
Yes, sir.
complete the construction of so and so station road earliest in the and also take necessary action to provide vehicular connectivity across the barricaded railway track by setting up a manned railway crossing at the spot of public interest.
Lordship.
So,
Lord-
what is the reply?
Well, here we have said, Lord, that there is no barricading in the railway line. In the affidavit, we have said, Lord, in the.
Where is that?
Lordship. But paragraph 4, Malad, we have said. 4. Paragraph 4. It is denied that, Malad, the last sentence, it is denied that there is obstructions by a barricaded rail track as the rail track lies on the opposite side. The road is an all-weather road which satisfy PMGSY norms, and all inhabitants are already been
So that there
connected by
is
the
no
road.
barricaded, this rail track is not barricaded.
Yes, Malad. But if any specific problem is there at this stage, Malad, I have to take action. Otherwise, we have said, Malad, the DPR and everything road is complete, Malad. They said that the road has to be completed 15.5 kilometer. That has been done.
Non-acceptability of the board.
Lordship, there are photos of the barricade on the last page of the petition, Lordship. Last page of the petition, the photos are there, Lordship. Page 58. Fifty-eight, Lordship, last page. Those are pillars along the railway line.
Which pillars?
Last page.
These are the placards, not pillars.
The page after that, Lordship.
It is in between the road.
Yes. Along the railway line. Page 58.
Yes, along the railway line.
Yes, along the railway line.
This one.
Yes. That is on the road only. That's where the road ends at one side and then the pillars are there. Railway line, then pillars again.
For providing this crossing and something that is for the railway and not for the PWDC. Providing crossing at this railway track, it is for the.
Lordship, there are
job of the
circulars.
Railway department, not of the PWDC.
There are circulars from the Rural Development Ministry also saying that when they make the DPRs, they have to take into consideration all these things, and then they have to make the rail.
When this DPR was prepared,
This DPR would be 2018.
why you have not raised objection at that time?
Lordship, DPR, after the work was done, Lordship, then only we got to know. We have filed RTI, then we received the DPR.
Malad, I don't know the of which place the photograph is, but paragraph 18 and 19 we have said, Malad. In the affidavit, page 63, Malad. Para 18 and 19, Malad. Para 18 and 19.
Yes.
Malad, the deponent denies that the railway line was barricaded on both sides of the road as the rail track lies on the opposite side, Borlongpar side. The railway track is set up long before the existing road alignment is fixed. The road is a link road status and is open to traffic from Lamding now. The road is an all-weather road, and this we have said.
Lordship, the project says that it is an approach road to Borlangfer railway station, Lordship. And now they are saying that it is connected to Lamding. Lamding is in a different district, Lordship.
Let him, Malad, if anything is there, let him reply.
If you are, in fact, if you want setting up a manned railway crossing at the spot, then you have to approach the railway authorities, not the state authority.
May I place this circular, Lordship? That is from the Ministry of Rural Development.
What it says?
It says, Lordship, may I read it? Please refer to your letter number so and so dated 10 February 2017 regarding road safety at unmanned railway crossing.
As you may be aware that the Pradhan Mantri Gramin Sadak Yojana gives utmost importance on the road safety. In this regard, this ministry in consultation with the states had issued a detailed circular to all the states, copy enclosed for ready reference, wherein it was clarified that though the low volume rural roads may not warrant construction of over bridges, the states must approach appropriate authorities for the use of Central Road Fund if overbridge becomes unavoidable. The states have also been advised to provide for rumble strips and cautionary boards at the PMGSY DPRs to erect these features as such crossings. As you may be aware that the Central Road Fund Act 2000 has been recently amended, and as per Amendment Act with effect from 1/6/2016, the CRF provides 16% cess on diesel and petrol for railway safety works, including the construction of road, either under or over the railways by means of a bridge or erection of safety works at unmanned railway crossing. While we are advising the state governments to take up the matter with concerned authorities and incorporate the provision in the future DPRs for providing manned unmanned crossing in respect of new connectivity roads to be built under PMGSY, you may direct the concerned authorities in the states to provide necessary support on the matter. The state governments are also advised to furnish proposals indicating the cost estimates received from the railways in respect of already sanctioned PMGSY roads for additional funds required for providing manned, unmanned crossings.
That's all. This fair petition is filed by the petitioner essentially being agreed with the action of the respondents of not completing the construction of the 15.550 kilometers of road from the road connecting Boran for railway station, the railway station approach road full stop. It is alleged in the petition that only 13 kilometers of road is constructed. However, on the portal of the respondents, it is shown that the road up to the length of 15.550 kilometers have been constructed. It is also prayed in the petition that the Boran, what's this, the name of Borlan?
Borlang Fair.
Borlan?
Borlang Fair.
Borlang Fair.
Yes, sir.
Railway station approach road be constructed up to 15.550 mark and necessary action be taken to provide the vehicular connectivity across the barricaded railway track by setting up a manned railway crossing at the spot. Good stop. In counter to the writ petition, the respondent department has admitted that though the road was constructed up to 13 kilometers, but on the portal, it was shown fully constructed. It is further submitted that now the road has been constructed up to complete length of 15.55 kilometers. While supplying the reasons for delay in the construction of the remaining part. Full stop. It is also submitted that, it is also mentioned in the reply that at present, the road is being used by the public. However, in respect of the barricading on the railway track is concerned, the same is denied. The same is denied. Full stop. Learned counsel for the petitioner has submitted that as per the instructions of the Ministry of the Rural, which ministry is there?
Lordship, this is the Ministry of Rural Development.
Rural Development. At the time of construction of a road under the PMGSY, the states are required to take into consideration to take necessary measures if there is any obstruction on the road on account of railway tracks, etc. It is submitted that the Rural Development Ministry of the Union of India has directed the states to construct overbridges out of the central fund if the same is required. Learned counsel for the respondent raised some time to complete his instructions on the above aspect. Full stop. Time prayed for is granted. In the meantime, time prayed for is granted and counsel for the respondent may furnish, may submit his response on the above aspect within a period of 4 weeks. In the meantime, the writ petition is admitted. No need to issue notice to the respondents as they are represented through the advocates.
Oscillometer 17.
Lordship, I prefer fixing of the matter in some other day, Lordship.
Why other day, madam?
Because or Thursday or Friday, I will not be available on Wednesday, Lordship.
Thursday?
Lordship.
A copy of the writ appeal may be provided. to
Yes.
me.
Yes,
You are in requirement of copy of the writ appeal.
No, Your Honor.
Oh, bless it.
Second. Item 19.
Lordship, this is we petitioner herein is CBSE, Central Board of Secondary Education. And I have challenged the order of the tribunal where the OA itself has been allowed and the transfer has, the respondent number 1 has been quashed. The admitted facts of the entire case is, Lordship, the respondent number 1 admittedly joined CBSE in 2002 and joined in Guwahati. From 2002 to till 2018.
Joined in Guwahati.
Guwahati itself. And he was kept on being promoted and kept in Guwahati itself till 2018. When he was transferred on promotion to Patna. In 2022, he was brought back to Guwahati. From 2022 November till date, he is posted in Guwahati as Joint Secretary.
Yes.
In the career of 22 years, he has only been transferred, that too technically, that was not a transfer in a technical sense, because that was only a promotional transfer. That unless you get it transferred somewhere, you will not be promoted. So he had no option but to take the transfer. So this was technically his first transfer in 22 years of
So
his career.
why you have again called him to Guwahati in 2022?
He had been making representations. In fact, we wanted to have.
At that time, you were kind enough to consider.
Yes,
him
yes,
being
I
consider this time also.
Lordship, the problem basically is multifold.
Yeah.
The problem basically which we are facing in this age, when Lordship, there was a NEET fiasco. There was a question leak all over. The 30,000 schools are affiliated to us. We conduct examination for class 10th and 12th, consisting of around 40 lakhs of students all over India, even abroad. Apart from this, we are also conducting other examination like CTET twice a year, and other examinations being offered by the ministries, different ministries. So throughout the year, there are different examinations. So in view of this, there has been overhauling of the entire transfer, and Lordship, there has been a 72 transfer by which the respondent number 1 has also been transferred. The only difficulty which he pointed out before the tribunal, that he is being transferred only after 1 year and 8 months. The policy says that normally it should be 3 years, except in administrative exigency and public interest. So we say that we have not violated the guidelines or the policy, transfer policy. In the administrative exigencies and in public interest, we have transferred the joint secretary from Guwahati to Thiruvananthapuram. A contention was also raised that the post which you are sending me to Thiruvananthapuram is not of joint secretary. And Lordship, what was transferred before the tribunal, because I appeared before the tribunal also, that the learned members of the tribunal wanted me to take instructions that whether we could accommodate him to any other place other than Thiruvananthapuram, which appears to the board as well as to the respondent number 1 to be a very far off place from northeast to southwest. The CBSE considered the suggestions given by the tribunal and made a transfer, which I have brought in affidavit, in my additional affidavit, that he may be transferred from Guwahati to Ajmer, which we have 3 offices. And the post of joint secretary was also there. That was not accepted by them. This was transpired on the last day. I brought on affidavit, additional affidavit, that the CBSE, the chairman has taken this decision subject to the orders, because the matter was pending. So I could not have implemented that order, though there was no stay order, but orally I said that we will not disturb till the matter is heard before the tribunal. So we made, and Lordship, there is an affidavit to that extent. If Lordship may have one page 357, starting from 356, if Lordship may have. This is the additional affidavit. We filed it before the tribunal. If Lordship may have 356, para 7,
Just a
decision. I'm sorry.
Yes.
If Lordship could have page 351, that is a copy of the order passed by the tribunal on 18th July, because on that day it was transpired and I made a statement being the standing counsel for the CBSC that we have nothing personal against anybody. And if it is being suggested by the tribunal to basically accommodate to him to some other places, we got it reconsidered. I personally met the chairman, said that if the impression is there in the mind of the respondent number 1, that he is being shifted to the farthest distance, though the distance today is immaterial, whether one is sent to Thiruvananthapuram or Ajmer or Patna or any other place, these being the All India services, we in view of this reconsidered and said that yes, we'll accommodate you there in Ajmer. We passed that order also. Now he had a choice either to join at Thiruvananthapuram or to Ajmer. But the point is, if Lordship could see his prayer in the OA, either keep me at the regional office Guwahati as joint secretary, head of the regional office, or please retain me in the same post where I am. So the punchline is that I need not be taken out from Guwahati. That is against the transfer policy in a services. This is basically against the jurisprudence of the service jurisprudence that nobody has any vested interest that he should have the place of his choice as a matter of right. If Lordship could see page 86, which is the last but one page of the impugned order passed by the tribunal, para number 10 of page 86. If Lordship has that.
Yes.
Para 10. You could see that I am seeing for the first time the distance is the impediment. In the instant case, para 10, I am reading, the applicant has been transferred from Guwahati to Trivandrum, a very far off place. Thus, there appears to be hostile discrimination and violation of Article 14 of the Constitution of the case. Because they say that out of 72, you have kept around 25 people at the same place, people from Noida to Delhi, Delhi to Noida, Ajmer to Mohali to Chandigarh. So you have not basically accommodated me in Guwahati. Lordship, had there been a strict following of 3 years of transfer, this would have been his 8th transfer in the career. He is there since 2002. It would have been his 7th or 8th transfer. But technically, it is either first or the second transfer. And another problem is saying that he's left with 4 years of service. In the transfer policy itself, it is stated that the last year of your service, you will have the place of your choice. You can have a hometown. So 1 year, if we deduct out of these 4 years, so he'll be left with 3 years from today. After 1 and 4 months, he will say that I'm not lived with 3 years. So please don't transfer me anywhere. So virtually he wants that the entire career he should be remained in Guwahati. That, Lordship, that is totally against the service jurisprudence. And Lordship, he is not the only joint secretary. There are 9 joint secretaries who have been transferred. There are 2 other joint secretaries who have been transferred to South India, one to Bangalore, other to Vijayawada. He is not the only person transferred from Guwahati. There are 5 persons who have been transferred. If Lordship may have, I'll just show Lordship the transfer order at page 126 of the paper book. If Lordship may have. If Lordship may have, page 126, this is the transfer order of 2nd of July 2024.
Yes.
If Lordship could see the 3 pages, the total number of employees who have been transferred are 72.
Yes.
Out of these 22, I have shown in affidavit, there are 19 employees who have been transferred before 3 years. If Lordship could see, after this serial number 3, from serial number 3 to 11 are the joint secretaries.
Yes.
From the joint secretaries, if Lordship sees the respondent number 1 here is at serial number 5, Jagdish Barman.
Yes.
If Lordship could see,
Yes.
he is head COE Guwahati to head COE Thiruvananthapuram, and Lordship could add that he is head COE Ajmer. And if Lordship could
Propose to transfer.
proposed to transfer, which he has a choice, which the CBSE has considered and conceded. If Lordship could see
Yes,
serial number, Lordship 9 and 10, both are also joint secretaries. One has been sent to Vijayawada, another has been sent to Bengaluru
from where?
from Delhi, Lordship. So they have also been sent to South India. Lordship, in fact, I should not have even argued this. And it is the prerogative of the employer to send and take work from a particular employee as it deems fit. So he is not standalone in any aspect. He is not standalone, and he takes a plea in his OA that I am a tribal, I am a ST, I am being victimized. There is no elaboration on this, and there could not be. There are 6 ST in all over 72. He says that I have been transferred before 3 years. This can't be the grounds, and Lordship could see the transfer policy, which starts from page Lordship 130. Could see Lordship 130. This is the transfer policy dated, which has been basically revised and updated as late as 7th June 2024. And there is an allegation that in order to shift me from Guwahati, you have basically overhauled the entire transfer policy itself.
This is what the allegation.
This is this allegation. There are 10,000 employees in CBSE for basically for victimizing the respondent number 1. We have changed the transfer policy itself, because there is in this policy, Lordship, there is a clause which we have introduced, is the hometown clause, because Lordship, the regional office is the most sensitive office where all the examination, question papers and everything comes. So therefore, we have brought in a clause that anybody who is posted in... Yes, Lord. If Lordship could have... I'll just... If Lordship may have 1.3 on the very first page of 130.
Yes.
No employee of the board, either on initial joining in the board at any level or on promotion to the post of superintendent and equivalent and above, which he is, shall be posted in the regional office having jurisdiction over the district of their hometown. So he challenges that you cannot basically shift my hometown, and this is basically not the clause which has been made applicable because he was not posted in regional office. So we have not even applied this clause on him. But because of this clause, there has been rampant transfer of the officers, so that the cartel, there should not be any cartel. There should not be any syndicate. There should not be any, basically any officer should not mingle enough to the local school and all that. So there could be the apprehension of leaking question paper set out, all things could be avoided. Though he has challenged this clause in his OA in detail, but we have not applied this clause on him because this clause doesn't apply. He was not posted in regional office. So therefore, there is no dealing on it. Lordship, the relevant clause which we basically applies here, if Lordship could have 1.1, just 2 clause above. 1.1 in 130. If Lordship has that. 1.1.
Yes.
If I may be allowed to read, Lordship, 1.1. All the employees of the board, including heads of the department, in exceptional circumstances, but not including the officers posted on deputation to the board by Government of India, are liable to be transferred anywhere in India in board's offices unit at any time, in administrative exigency and in public interest only, except in the regional office having jurisdiction over the districts of their declared hometown. So, Lordship, this clause, if I may be, Lordship may be allowed to elaborate, is that all the employees of the CBSE, including the level of directors in exceptional circumstances, there are 3 exceptions. Those who have come in deputation, we will not touch. Those who have got their hometown in the regional office, they will not be. And those directors who they are not in exceptional circumstances, all employees of the CBSE can be transferred to any place in India, in any unit, any offices. This is one general clause I am reading. If I lordship may permitted to read page 131, clause 2.1, which has been alleged to have been recorded that I have violated in the impugned order. If lordship may have 2.1.
Yes.
The tenure of regional office, head COE, he is the head COE here in Guwahati, shall normally, if lordship may mark the word normally, be for a continuous period of 3 years, term from the date of her posting transferred to a regional office COE as regional officer head of COE, except, lordship may mark the word, except for administrative reasons in public interest. Effort should be made to provide stability of tenure or regional office at COE. The question arose as to whether I have violated this clause or I have adhered to this clause. This is the question, lordship. This is the question which I might ask myself. I'm saying that I've adhered to the clause. Keeping somebody to the tune of the post of head COE, then normally it should be 3 years. But in exceptional circumstances, which is the administrative exigencies and public interest, 3 years period is not the sine qua non. That is what I get from this reading this 2.1. If lordship, I may, lordship, bring the attention of this honorable court to clause at page 133, clause 7.5. 133, lordship has that.
Yes.
7.5, if lordship, I may read, notwithstanding these guidelines, chairperson CBSE shall be the competent authority to transfer any employee of the board for administrative exigency and in public interest over and above these guidelines. There are 19 officers in the list of 72 who have been transferred before 3 years. There is another employee in Guwahati who has been transferred in 5 months. There are 6 ST who have been transferred in 72. There are 9 joint secretaries who have been transferred overall. There are 3 joint secretaries who have been transferred to South India, which in fact, lordship, I feel that I should not argue even that I'm arguing that why he has been transferred to South India, North India, East India, West India. And lordship could see the allegations because lordship, I need not elaborate on the point that the judicial review of the transfer is very limited, is a settled law. Limited to the extent of 3 points. The first point is that it is issued by an incompetent person. That is the first point. If there is a violation, if it is by incompetent, it will be set aside. The second point is that it is in violation of any statute. And the third point is that it is done in mala fide. Out of the 3 points, the tribunal says that first point clear. By competent authority, chairman, who is the additional secretary. The next 2 points, the court tribunal says, it appears that there is a mala fide. Because you have not transferred so many other people, you have transferred to very near about places, and you have transferred this person to very far off place. There can't be a negative comparison, lordship. For a mala fide to be shown, there has to be that his transfer has been done with certain malice or mala fide. The mala fide is not established that out of 72 to certain persons who have transferred to very near of places, therefore it is a discrimination, a hostile discrimination against me. I should also be transferred to a very near about places. Once you have transferred me from Guwahati to Thiruvananthapuram or from Guwahati to Ajmer, it appears to be a very far off place in comparison to some selected few, which you have not transferred to very far off places. Therefore, it is a discrimination, arbitrary, and a hostile discrimination violative of Article 14. This cannot be, lordship. The comparison has to be between the equals.
Yes.
That is the law.
Yes.
The equals are joint secretaries.
Yes.
The 9 joint secretaries have been transferred. Out of the 9 joint secretaries, 2 other joint secretaries have also been transferred to the South India, and he has even been given an additional option of joining at Ajmer. And if Lordship, I could show from the OA as to what are the things they have written for Malaf ID. Before that, I would like to read the 2 paragraphs of the impugned judgment, Lordship order. If Lordship may have para 8 at page 84.
Yes.
This is the Lordship adjudication. The earlier part happens to be, though my grouse here, that my contention have not been recorded, but that is immaterial if I am able to, Lordship, satisfy this honorable court, be that as it may. If I, Lordship, may be allowed to para 8, read para 8 onwards, page 84, 2 page only I'll read. As per settled principles of law, transfer can be interfered only when one of the following 3 grounds are violated. Transfer order issued by an incompetent authority with no locus standi. Lordship, this is not the issue here because it has been held that it has not been issued by an incompetent person. Lordship, point 2. I have a problem with the point 2 which has been recorded in para 8, if Lordship may see that. It says that transfer order made in contravention of extant HOA orders, rules and transfer policy. It could be only statute, Lordship. It cannot be guidelines, executive instruction. There are judgment of the Honorable Supreme Court which say that even if it is in violation of any administrative order, it will not be amount to violation of statute, because what is to be seen is the administrative exigency and public interest. Third point is transfer made on Malaf ID ground. If Lordship see how it has been dealt with, examining objectively the above 3 grounds, it transpired that only one ground, transfer order issued by an incompetent authority, has not been violated in this present case. The impugned transfer order dated 2nd July 2024 has been issued by Mr. So-and-so, Secretary CBSE, with the due approval of the competent authority of CBSE chairman. Thus, the transfer order of the so-and-so is legally tenable. Lordship may have the next 2 grounds. However, as far as the second pillar of violation of statutory order and rules and transfer policy is concerned, it is seen that there has been a violation of the CBSE transfer policy in this case. As per para 2.1 of the transfer policy, an officer should ordinarily serve on a posting for at least 3 years. In the instant case, the applicant had joined as head of Center of Excellence Guwahati on 9th November 2022 and has been abruptly transferred to Center for Excellence Trivandrum after completing only 1 year and 8 months. There appears to be no administrative exigency. Lordship, I have an issue on this. Public interest served by abruptly aborting the 3 years tenure of the applicant and transferring him to Center for Excellence Trivandrum. The learned counsel for the respondent's argument that being a joint secretary level officer, he would serve the interest of Center of Excellence Trivandrum better cuts no eyes, as by this transfer order, Center of Excellence Guwahati's interest would suffer when the private respondent Sri Arvind Kumar Mishra, Under Secretary, joins from Patna. This argument, Lordship, this Lordship observation itself, also this transfer violates DOPD transfer guidelines that as far as possible, husband and wife should be posted together. The word itself has been used as far as. Applicant's wife is teaching in Assam Textile Institute, Guwahati, and transfer should not be done in the academic mid-session of a school-going child's applicant. Daughter is studying in class 8 in school of Guwahati. The third pillar, Malaf ID, also appears to be proved in the instant case. Without discussion on Malaf ID, Lordship. It is seen that in the impugned transfer order, there are many officers who continue to be posted in Delhi, transferred from one place to another post only, or transferred to nearby places of their old posting, Delhi to Noida or Chandigarh to Panchkula, Mohali. In the instant case, the applicant has been transferred from Guwahati to Trivandrum, a very far off place. Thus, there appears to be hostile discrimination and violation of Article 14 of the Constitution of India. The argument of the respondent counsel that the transfer is the natural right of the respondent and that the respondents are fully empowered to use their discretion to transfer and posting cuts no eyes, as it is a settled principle of law that discretion can never be absolute and unfettered. In the light of the above, we are of the considered opinion that instant OA has merit, deserves to be allowed, and is therefore allowed. The respondents are directed to allow the applicant to continue in his present posting as joint secretary so and so, so and so. If Lordship could see as to what is the ground, Lordship, if there is absence of malafide, the exigency itself is proved. So therefore, for malafide to be established, I'm not saying that it has to be a beyond reasonable doubt as we find in the criminal cases, but there has to be enough material for malafide. And what is the grounds, what is the pleading for malafide in the OA is very relevant. And I will, Lordship, just point out his OA also. If Lordship may have his OA, which starts from page 88. I will not, Lordship, take to the entire OA, only where malafide has been stated. The first page is page 100. And if Lordship starts from page 99, last 3 lines. Last 3 lines from page 99, the applicant had been made to work in lower rank, status and post with inferior duties, responsibilities and function against his juniors while working as head COE Guwahati, which is actually suitable for an academic cadre of under-secretary training. The action of the respondents in denying the applicant posting as regional office RO Guwahati, which is suitable for the post of joint secretary held by him, is arbitrary and illegal, being violative of Article 14 and 16 of the Constitution of India, and speaks of malice and malafide. What the case they were trying to set up that the post of joint secretary, he should have been posted in regional office Guwahati and not as a head COE. Which is, Lordship, he had asked in the prayer also, which has not been given. If Lordship could see his prayer, that will be, Lordship may appreciate in the perspective as to what is the reason for pleading such things. If Lordship may have his prayer, page 123, para 8.1 onwards. Lordship has that?
Yes.
8.1, impugned transfer order did be set aside. 8.2, the Honorable Tribunal be pleased to declare that the exception barring posting for and above the post of superintendent in the regional office having jurisdiction over the district of the declared hometown as contained in para so and so of the transfer policy are arbitrary and illegal. This was not even applied on him, Lordship. May have this. 8.3, impugned para so and so of the transfer policy dated so and so far as exception barring posting for and above the post of superintendent in the regional office having jurisdiction over the district of the declared hometown be set aside in quest. The Honorable Tribunal be pleased to direct the respondent to grant the applicant posting as regional officer at the administrative unit of RO Guwahati, which is commensurate to his administrative cadre of joint secretary, and allow him to continue in the present place of posting as head COE. And Lordship, this is alternatively. Allow him to continue in the present place of posting as head COE Guwahati in the light of the DAPOD OM number so and so on a spouse posting in the same station and para 2.1 of the transfer policy dated so and so, any other relief. So, Lordship, there are 2 offices in Guwahati. One is called regional office and one is called the COE, Center of Excellence. Both are in the same building. RO has more responsibility towards the affiliation, examination, question papers, everything. But even the personals from the COE are given examination duties. Both are situated in the same building in Guwahati. The highest sanctioned post for COE in Guwahati and many other places, somewhere it is deputy secretary, somewhere assistant secretary, it is not a joint secretary. But at many places, joint secretaries are being given this post, keeping all his status, perks, privileges intact to work as head COE at big places like Guwahati, Thiruvananthapuram, and many other places. The reason behind it, Lordship, is that COE, the duty primarily of head COE is to train the teachers of the school. In the case of the respondent number 1, which has the jurisdiction all over Northeast region, he has to train the teachers, which are thousands in numbers, in view of the new education policy, NEP 2020, in view of the provisions of POSH, in view of the provisions of POSCO, more sensitization have to be done to the teachers and students in any school all over India, which is, Lordship, has become a sine qua non for the new education policy also. Therefore, many places, persons of joint secretary are also given responsibility of head COE. So what respondent number 1 is asking in his OA, that please put me as a head of regional office.
He was posted as a COE since 2022.
Yes.
And he has not made
No.
any such demand.
And he was being given the head COE in Thiruvananthapuram. But he raised the issue that even in Thiruvananthapuram, the post sanction is under secretary. So I am joint secretary. I persuaded the chairman. So don't have this thing in the mind of the respondent number 1. He was given in Ajmer the post of joint secretary as head COE. In Ajmer, the head COE is held by a joint secretary. The sanction post is joint secretary. So at least this he will not have in mind, that he, despite being joint secretary, is not given the post commensurate with his services. And even there should not be, it should not be in his mind that he is being sent from northeast to southwest, the largest distance one can cover. But even that is not acceptable to him. He says that I will please place me in Guwahati at any cost, put me as regional officer Guwahati, or in the alternative, keep me remain in the same post, even if he admits that that post is not commensurate with the joint secretary. If Lordship could see that even the tribunal went ahead and asked me, please explain your administrative exigency, though not in writing, but say that you please file an affidavit and show all your administrative exigency, transferring this respondent number 1 from Guwahati to Thiruvananthapuram. Even we did that. If Lordship, I filed my affidavit, which is not the requirement of law. The entire ingredients of administrative exigencies need not be brought to in the public domain as to what are the factors which are working in the mind of the employer, and in an institute which is of all India level, which conducts examinations.
Where is that affidavit?
Please, Lord. If Lordship may have, my detailed reply affidavit starts from page 221. And the relevant portions, which I should say, we explained everything. If Lordship may have, page 230, for example, clause E. We explained everything with charts, with details. Clause E, if Lordship may have, page 230.
Yes.
Several officers in the impugned transfer order were relocated before completing their normal 3 years tenure. For instance, officer at serial number 4, 8, 9, 11, 14, 17, 33, 34, so and so, which are total 19, have been transferred before completing 3 years of their respective posting. The employee at serial number 2 has been transferred only in 6 months from Guwahati itself, Lordship. If Lordship would further read the administrative exigency, if Lordship may have F, a paragraph below, that the chart prepared by respondent CBSE with respect to all the officials mentioned in impugned transfer order would establish that the transfer order is a mixture of routine rotational transfer done in administrative exigency and in public interest, and transfer done in terms of clause 1.3 of transfer policy regarding the declared hometown clause where the jurisdiction of the RO exists. Copy of so and so. The transfer of the applicant has been done in administrative exigency and in public interest, keeping in mind the organizational needs and efficiency optimal resource allocation and meeting the dynamic need of the organization. Apart from the 2 transfer order dated 2nd July 2024, there are more transfer on the anvil, which would again be mixture of routine rotational transfer in administrative exigency and public interest, exceptional transfer in public interest, etc. NEET fiasco, leakage of papers in UG medical entrance examination has rocked the entire country. Even the incidents of question paper leakage, malpractices in examination center, etc. have increased in the recent past. CBSE has around 30,000 schools affiliated in India, including some abroad, and conduct examination of around 40 lakh students for class 10th and 12th every year. Apart from these classes, 10th and 12th examination, CBSE also conducts examinations such as CTET, Navodaya Vidyalaya, KVS, EMR, so and so. All the officers, including that of COE, are given examination duties, which themselves are very sensitive aspects of the working of CBSE. In fact, all the aspects of administrative exigencies and public interest element cannot disclosed and detailed. Some of the centers of excellence have been co-located at regional office, and the CO Guwahati is one such COE, which is located in the same building in which RO is located. Therefore, in such situation, office of CEO at such location becomes a sensitive place for CBSE. The COE has primary, Lordship may read, Lordship may go through this. The COE has primarily responsibilities of training teachers of the different schools affiliated with CBSE, which includes teaching management, class management by teachers, student management by teachers, etc. In the recent past, after the new education policy 2020,
So you have shown this
all things, Lordship, the POSCO, the POSH, the right of person with disability, that the school teachers need to be very sensitive to all these aspects. So in view of all this, we wanted to show to the tribunal that from Guwahati, and we have in fact praised him that he has done a good work in Guwahati, that we need head COE as a post of GS at Trivandrum. Despite his objection to this fact that I'm not being commiserated.
But if he is not accepting your praise, then what to do? He's not.
Then he has to leave the job. Then he has to leave the job. Lordship, I'll just show one thing very important. When he basically joined this, he was working, Lordship could see is very interesting. Lordship asked me this. When he was, Lordship, working, I have annexed with my, if Lordship may have, page 268. This is his attestation form. And page 271 is the relevant page.
Yes.
Page 271, if Lordship could see a paragraph below the last, just above the last paragraph, written in with pen, assistant under scale of so and so, Assam University, Central University, PO Assam University, District Catcher, Assam. From 1904 to 2002, he was working as assistant in Assam University, which is located at the same place. So he chose to leave this service and joined a service of All India Transfer, a service which has an All India Transfer. So he cannot at least complain. He was not taken by surprise. That was his on his own volition, that he joined the service in 2002, and we were basically from 2002 till date.
Yes.
So in view of this, Lordship, this transfer holding it to be a Malaf ID. And Lordship, I just showed one paragraph. I'll just show another 2 paragraphs of what he's pleaded in Malaf ID. I'll just finish that by that. Lordship may have that 2 line more from what he has pleaded in his OA. If Lordship, I had shown that one, that is Malais and Malaf ID, which he says, start from page 88 in his OA, and the relevant portion will be, if Lordship have start 103, the first paragraph, last 4 lines of 103. While he challenging that hometown clause, which is not even applicable on him, he writes in the last 4 lines of first para, it is stated that the action of respondent amounts to changing the rules of the game during the middle of the game, which is barred in terms of the settled position of law. Malice and malafide against the applicant is patent. So for him, being posted in Guwahati is a game for 22 years. So he says that once you change the rule that he will not be posted or anybody will not be posted in the RO, is changing the rule of the game in the midst of the game. So for him, the game is for 8 years for his entire career.
103,
103, first paragraph, last 4 lines.
changing game.
Change. This is with respect to what, I don't know. This is the malafide.
Game, and if he says something else.
No.
That hardly matters.
Lordship, next
Then
page,
maybe that the-
next para, page
but
104.
the, Language of the advocate depends upon.
What we say, the smartness of the advocate, or he puts everything in few words.
Whatever it may be. that
Lordship, 104 may
matters.
say, 104, last 4, I'll start with, this is the last paragraph I'll read, the last 4 lines. It is stated that respondents seek to deny the due posting to the applicant as joint secretary in the administrative unit of regional office Guwahati, since he had filed OA against the respondent department in the past. However, it is stated that no AA filed by the applicant against the respondent department is pending as on date. Malice and malafide against the scheduled tribe employee to indigenous Dimansa community of Assam is patent. So anybody under the sky can take any plea of malafide saying that I'm a Muslim, I'm a Hindu, I'm a Brahmin, I'm a Dalit, so I'm being discriminated. So this is what the OA asked for. When we produce the entire detail, no, you have not transferred 25% out of 72 to far off places and to very near of places. Therefore, it is a violative. And Lordship, in my additional affidavit, I have explained that those 25 people, what had happened, Lordship, that there were some officials, around 9 or 10 officials, who had just come from a outside posting to Delhi or Noida in January, February, March 2024, or in the last 3 months of the 2023. Because of the hometown policy, they have to be shifted from regional office to some other office. So therefore, we did not send him to a far off place. So the question.
Yes.
Lordship, the yes, may have page 166. He takes all possible grounds available to him. He
Supposed to take all possible grounds available to him.
I could understand
You
the
consider
legal.
the objection regarding that.
No, I'm not on that.
If a person
Anybody is,
taking-
Lordship, anybody is entitled,
Even though not available to him, he can take this ground.
but
those
he
grounds.
must come clean.
It is for the.
But he
authority
must
to
come
consider.
clean to the court. That is the
That's
point.
That's another.
Lordship could see 160. I'm not saying that one is not entitled to take any plea. He feels like all available under the law, permissible under the law. But you must come clean to the court. That is the point I'm trying to say, Lordship. Before I could finish my sentence.
Yes,
So Lordship could see page 166.
yes.
The grounds also he has taken that he is suffering from some problem. The problem which he has stated, Lordship, in 2024, July, he filed and says that files a report of 1st September 2023. Lordship, I'm sorry, I'll first show page 109. I'm sorry. If Lordship could have, I'm so sorry. 109. 109, 4.19. If Lordship may have that. I'm so sorry. 4.19.
Yes.
4.19, that the applicant is a patient of type 2 diabetes. He is under medication and dietary restriction and is under advice of doctors who have home cooked food. His wife is also suffering from hyperthyroidism, vitamin E deficiency, and low hemoglobin level. The problems which are narrated are basically faced by almost so many Indians at this stage. And is the Lordship could, what is interesting is at page 166, he annexes the medical records, which is of 2023, February, September, one report, hemoglobin is low, one report that he is having some diabetes. This is not the end. What Lordship was done at page 342, he was transferred in 2016 also, which he had challenged and won in before the tribunal, which we did not challenge further. In 2016, before he was sent on promotion to Patna, he was transferred first time in 2016. He challenged it before the tribunal. That time there was no transfer policy in place of CBSE. So on the basis of the OM, that the husband and wife should be kept at one place only, the wife is also working. So the OM was allowed. We did not challenge it, that in any case, after some time, he is being promoted and transferred. In that order, if Lordship, I'm trying to show as to what is the pleadings and what is the observation, page 342. Lordship. First 4 lines of page 342.
Yes.
Elder daughter is studying in class 6 and younger daughter is studying in KG, and his wife is suffering from pelvis inflammation disease since 2014, and she is under treatment at Guwahati. The applicant is a patient of chronic kidney disease. So the disease, the problems medical also changes with time. So with every petition, every OA, he has different set of medical issues. And he did not even press that. As far as the study of children, anyway, as far as study of children is
not taken into consideration.
no problem. As far as Lordship, the one ground which has been taken, that wife is also.
Basically, you have two grounds. That violation of this, first of all, there is no such violation of the transfer policy. And even though if the violation is there, the transfer cannot be, the transfer order cannot be interfered.
At best be it is administrative.
And secondly,
Malafide.
that malafide, no such malafide is wrong to that. That
And
is what-
third is Lordship, there cannot be a Lordship negative comparison.
That's another. That's
And one thing I just like to inform this honorable court is that a ground which has been taken, an observation made that the daughter is studying in class 6. The CBSE has a provision that wherever the employee is transferred, then all over CBSE school, they have to take admission of the wards of the CBSE employee, because maximum schools are affiliated to CBSE. So they ensure the schools where the employee is being transferred, the schools there in that particular town are CBSE, mostly are CBSE affiliated. So they have a system that they allow the ward of the transferred employee to take admission in any of the CBSE schools.
That's another, that is. a-
So that
whether-
basically
whether-
ensure that
Whether he is shifting his, on transfer, he is going to shift his daughter or not, that's another question.
which has not been pleaded
Since-
even.
Since his wife is there, he may not be interested in transferring the daughter with, in that school of where he has been transferred.
And in Lordship, see, what is the clause in transfer policy with respect to the spouse working? And that is the last argument I'll.
Okay, fine.
Just see Lordship. If Lordship may have the transfer policy at page 130,
As far as,
as far as. So therefore, what my submission is that the tribunal ought not to have traveled to a distance of getting into the administrative exigencies and then holding that there is no administrative exigency. To that extent, Lordship, I have all the judgments, which I may say after in the rejoinder if my learned friend says so. Lordship, I will have the judgment. Much obliged for the patient hearing, Lordship.
May it please your lordship. If I would have died by now, then I would have proved my point that in 2016, I was having some kidney problem. Because I have not died, therefore that is a stand which is not believable. Is it an argument, my lord? Is it an argument? Why people cannot, recover from any disease? Is this the mindset of CBSE or it is the mindset of the lawyer representing the CBSE? What is this, my lord? Making certain personal attacks, hitting below the belt is not fair. Anyway, that's besides the point. First, my lord will kindly, my learned friend first started his argument saying, I joined CBSE in 2002 and until 2018, I was in Guwahati. My lord, the first transfer policy of the CBSE came in 2018. There was no requirement. So therefore, my lord, and it is not that at my prayer you have kept me here. It was in now that same administrative exigency on which now you transferred me on basis of the same administrative exigency, my lord, I served at Guwahati. So my lord, that argument is neither here nor there. My lord, tribunal has basically taken note of 3 points. First is violation of the transfer policy. It's not mala fide in the sense we understand. What tribunal has taken note of is, my lord, malice in law. And third is, my lord, and the third is requirement of posting husband and wife in the same location. These are the 3 basic grounds which the Honorable Tribunal has taken note of. Now, my lord, will first come to page number 147. I agree with my learned friend when he says a litigant must come clean. Yes, here CBSE also should have come clean. Please come to page 147. Yes, regional office at Guwahati, which is the top post, joint secretary of which I am. Then deputy secretary, then under secretary. My lord, I was COE, Center of Excellence Guwahati. It's an under secretary rank post.
Sir, you
No, I'm coming.
Since 2022, have you raised any objection?
No, I'm not saying. No, I'm not saying that. That's why. That's why. Now, my lord will kindly come to the impugn transfer order, which is at page 126. 126.
Yes.
Serial number 5 is the applicant, the respondent. Jagadish Burman. I was head CEO Guwahati. I have been transferred to head CEO Tiruvanthapuram, my lord. It's an post held by assistant secretary rank officer. Fine. So is it not a violation of my condition of service? Now, my lord. Now, these are the broadly our argument, my lord. Please come to the transfer policy. The transfer policy is in, my lord, page number 130.
Yes.
That's the new policy. Now, please come to page 131. This is the clause which my learned friend has referred. The tenure of regional office head of CEO shall normally be for a continuous period of 3-year term from the date of his or her posting transfer to the regional office CEO as a regional office, except for administrative reason in public interest. Efforts should be made to provide stability of tenure of regional office head office. Now, my lord, yes, in administrative exigency, even before completion of a tenure, an officer can be transferred. For that, no judgment is required. It's a settled position. At the same time, policy also says effort would be made to provide stability of tenure of regional officer and head CEO. That means an effort must be made. The lordship would be surprised to know in Guwahati regional office, a gentleman called Sandeep Tandon, who is of the deputy secretary rank, he is holding the post of my lord joint secretary.
That was not I'm just taken into consideration by the tribunal.
No, my lord, what I'm trying to show is, no, my lord,
Not even
no. A holier than thou stand is sought to be taken by the CBSE, my lord. What I'm trying to show is, I say I have yet to complete my tenure of 3 years. That is my basic case. How can you ensure that stability of tenure? you can ensure that stability of tenure by also posting me as Joint Secretary RO. Because presently, one gentleman called Tendon, who is Deputy Secretary rank officer, he is holding the post of CEO, my lord, as a regional officer. And my lord, I belong to administrative cadre. I don't belong to academic cadre. And the CEO is a post, my lord, which falls in the academic cadre. My lord. I am basically a man from administrative cadre. Now, please see, my lord, page 156. Yes. An All India listener. Kindly see, my lord, page 156. I am at serial number 1, 2, 3, 4, 5. Kindly see, my lord. And at page 157, this is the seniority list of academic cadre, my lord. I don't even figure. I belong to this administrative cadre at 156. Why these facts are not pleaded? I don't even belong to academic cadre. I belong to administrative cadre. So what is the answer, my lord? These are the stands we have taken in our OA. These are not even adverted to.
Sir, so far as regarding the Sandeep Tandon and something else is
Yes,
concerned,
yes.
no such argument is before the OA.
It is there, my lord.
It is there, the tribunal has summarized your arguments in 15 at.
Basically, my lord, basically tribunal has.
That is, you just.
Yes,
just-
yes. And even in the order also that is reflected, my lord.
Can we see?
Yes.
This-
No, my submission is.
Just the. This page number 70.
Yes.
Please.
Page 7.
Learned counsel for the applicant doesn't can do assisted by so and so.
Hmm.
Adduce the following 15 arguments in favor of the case.
In fact, my lord, page 71, these are the grounds. Non-completion of tenure of 3 years in non-sensitive posting. Then
These 15
discrimination
grounds,
against
They have
employee retained at the.
quoted all these 15 grounds.
Yes. Yes. Huh?
All these 15 grounds.
Page number 78, my lord.
78.
Yes.
Yes.
Claim for posting at vacant post of Joint Secretary at RO Guwahati pending. Page number Roman 10, my lord, at page 78.
Now some other person has already been posted at joint secretary in Guwahati.
No, that tendon is still continuing.
Lordship,
He in charge.
may I just clarify one?
No, you'll get your turn. Let me
I'm
come-
just
let me
clarifying
complete.
this point. A joint secretary personnel from Trivandrum to Guwahati joined in 2022 as head RO. But there was some complaint against him. There was an inquiry, then he was shifted from Guwahati to Delhi head office. Therefore, Tandon has replaced. So it was in fact joint secretary from Trivandrum.
My lord, in this exercise, they could have taken note of the fact that I have not completed my tenure. And the RO office, which is the joint secretary level post, is retained by, is being manned by a person who is of the deputy secretary rank. Does it reflect application of mind of the authority or it is a mechanical exercise of power? My lord, in a transfer matter, I will not trouble your lordship with all these intricate questions. Matter is very simple. There is a transfer policy. Transfer policy ensures a stability of tenure. Now, Honorable Supreme Court has come down heavily on this, my lord. I'll refer to the judgment of the Supreme Court, where, my lord, they must come up with reasons.
2013.
Yes. If your lordship will kindly come to, so before that, let me place one more thing, my lord. Now, please come to this notification at page 328. Why, my lord? Prior to 18, there was no necessity of transferring me out. Page 328. It is notified that the following posts have been identified as sensitive posts in CBSE headquarters and different unit offices of CBSE. The official posted below mentioned posts will be subject to transfer rotation as may be feasible in accordance with the extent instruction of the relevant authorities on the subject. Kindly see, my lord, these are the posts at the regional office. Please come to somewhere in the middle. Regional officer, irrespective of level, joint secretary, all posts, deputy secretary, all posts, executive engineer, junior, all posts. It does not include, my lord, CEO, COE. These are sensitive posts. Now, read with this, please come to, my lord, 2.2 of the transfer policy at page 130. Uh, 131, my lord.
Yes,
2.2.
yes.
All Group A and Group B officers on sensitive posts shall be mandatorily transferred, rotated after every 3 years from their respective posting, assignment to another department. If you are deriving your,
But they are not relying on this. They are only on 2.1.
no, my lord, what I'm
They are
saying.
not saying that the
No, no,
since he
no,
was
no,
working
no,
on
no.
the sensitive,
Per-
therefore.
No, no,
he's
perhaps
transferred.
I could not make my point, my lord.
Yeah.
What I'm trying to say by referring to 2.2 is, in case of non-sensitive post, there is no requirement of transferring somebody on completion of 3 years. They can be retained also.
No, no.
No, that is very material in this case, because I am holding the post of CEO, COE. CO is not a sensitive posting. So as per the transfer policy, one who is holding a sensitive post, he has to be
COE
mandatorily transferred out.
COE means, what is the
Center of excellence.
center of excellence?
Center
Excellence.
for excellence.
Center for.
Center of excellence.
Sorry, center of excellence.
So a person who is holding the post in the academic cadre as a COE, he need not be transferred out on completion of 3 years. He can be retained for more than 3 years.
Here in your case, even though they have not allowed you to continue the 3 years.
No, no, my lord will kindly appreciate what I'm trying to say. What I'm saying is, on one hand, you are transferring me to a post which is not befitting of my status. Secondly, under the policy itself, you are not supposed to disturb me now. That's what I'm trying to say, my lord. Under this clause, as a officer holding office on COE, there is no requirement on the part of the CBSE to transfer me out immediately on completion of 3 years also. So I have not even completed 3 years. So my lord, stability of tenure is one aspect which authority has not taken note of while making by transfer. At least until completion of 3 years, my lord, I could have posted a regional office at Guwahati by transferring the gentleman called Tendon to somewhere else.
Tandon is not joint secretary. He is simply holding the post.
So my lord, that means substantively that post is vacant. No, lords will kindly appreciate me, lord. I know in a transfer matter, this scope is limited. But it's not that merely because it is a transfer matter, my lord, there will be a judicial answer. There is no such law. Now, my lord will kindly come to the judgment of the Supreme Court.
Yes.
Before that, one more DOPT guideline, my lord, at 337.
Yes.
This is an office memorandum of 2nd of July 2015.
Yes.
The undersigned is directed to refer to the OM of event number dated 13th of June 14 and 31st of July 14, wherein all ministries, departments were requested to prescribe minimum tenure, set up a mechanism akin to Civil Service Board for recommending transfer, and 3, place in public domain the transfer policy. The rotational transfer policies should aim to harmonize objectives of institutional memory, avoid development of vested interest, and promote exposure to the employees of working in different organizations, entirely ensuring overall growth of an officer. Transfer policies should provide for both a minimum as well as a maximum tenure. Any transfer before completing the minimum transfer tenure, prescribed tenure,
or stay beyond the maximum period should be with the approval of the committee constituted for the purpose for reasons to be recorded in writing. So my lord, this is the broad policy of the government of India regarding minimum and maximum tenure of an public servant, civil servant. Now, Supreme Court has ruled on this that your lordships will get at 190 and the operative portion is at 207 and 208.
190.
It starts at 190, my lord. I'll have your lordship's kind attention to page 207. CSB consisting of para 28 at page 207. CSB consisting of high ranking in service officer who are experts in the respective field with the cabinet secretary at the center. And the chief secretary at the state level would be a better alternative to guide and advise the state government on all service matter, especially on transfer, posting and disciplinary action. Though their views could also be overruled by political executive, but by recording regions, which would ensure good governance, transparency and accountability in governmental function. Parliament can also, under Article 309 of the Constitution, enact a Civil Service Act setting up CSB, which can guide and advise the political executive, transfer and posting, disciplinary action, etc. CSB consisting of experts in various fields like administration, management, science, technology could bring in more professionalism, expertise and efficiency in governmental functioning. We therefore direct center, state government and union territories to constitute such board with high-ranking service officers who are specialists in their respective field within a period of 3 months, if not already considered, till Parliament brings in proper legislation in setting up CSB. We notice at present civil servants are not having stability of tenure, particularly in the state government where transfer and postings are made frequently at the whims and fancies of the executive head for political and other consideration and not in public interest. The necessity of minimum tenure has been endorsed and implemented by the union government. In fact, we notice almost 13 states have accepted the necessity of a minimum tenure of civil servant. Fixed minimum tenure would not enable civil servant to achieve their professional target, but also help them to function as effective instrument of public policy. Repeated reshuffling transfer of officers is deleterious to good governance. Minimum assured service tenure ensures sufficient in-service delivery and also increase efficiency. They can also prioritize various social and economic measures intended to implement for poor and marginalized sections of the society. We therefore direct the union, state government, union territory to issue appropriate directions to secure providing a minimum tenure of service to various civil servants in a period of 3 months. Now, my lord, end of the day, what transpires is, my lord, here is a case. For the first time in 2018, the CBSE came up with a transfer policy. And the transfer policy envisages a tenure of 3 years. We do not dispute that even before 3 years in administrative exigency, an officer can be transferred out. But the same policy also says 2 things, my lord, that as far as possible, it must be ensured that the tenure is completed. And number 2, persons who are holding non-sensitive posts, they need not be transferred out on completion of 3 years. Coupled with that policy, if we look at the observation of the Supreme Court in the judgment, the principles which clearly emerge is that, my lord, if the authority is to do away with the policy, then it must record reasons. At least the file must be placed. The file where the decision-making process to transfer these officers were made, that file must be produced. It's a certiorari proceeding, my lord. If they do not produce the record, lordship will draw an adverse conclusion. Question is how they dealt with it, how they applied their mind to the relevant considerations. The relevant consideration is the policy and the decision of the Supreme Court. And incidental matters are, my lord, that the post of RO is vacant in Guwahati. I have not completed 3 years, and it is being manned by an officer who is of the rank of Deputy Secretary. The post where I am being transferred, my lord, it's a post where it is assistant secretary rank post. I am a joint secretary rank post. Therefore, in my humble submission, my lord, looking to the
Now, as per their proposal,
Yes.
they are proposing to transfer you on a joint secretary post in Ajmer. So accepted.
We have decided, issued order also.
They are doing it.
Huh?
They have filed an
Yes.
affidavit of this.
No, order has not been given to us.
Yes, we
We
can't
pass
give.
an order. If you are
Any
agreeing to
issue.
it. Yeah.
No,
when
that
you-
we'll have to ask our client, Mila.
Ask your tomorrow. Complete your inspections tomorrow.
They had refused there.
My lord, could
Complete
your
your
lordship,
inspections tomorrow.
tomorrow, day after tomorrow, my lord. He says he has some difficulty tomorrow, my lord. Tomorrow,
Lordship,
day after
because
tomorrow.
I have also come from Delhi, if Lordship could have it on 22nd,
22nd.
of this month.
Today is the
19th.
22nd. No, then only 19th. Today is
Today is 19th, Lordship. 22nd, if Lordship could keep. Lordship, 21st, I won't be able to, there are some batch matters before, listed before the special bench in Delhi High Court.
why don't you complete your instructions by tomorrow?
My lord, it may not be possible, my lord. He has some difficulty tomorrow. No, just now he said he has some difficulty tomorrow.
The person is
Even-
Guwahati only.
No, my lord.
Even I'm in difficulty tomorrow, Lordship. I have a flight today to catch, Lordship, I have a matter. So requesting for 22nd, if Lordship could accommodate.
22nd.
Much ado.
Complete your instructions. They are posting you on a joint secretary post, which is befitting to your status.
No, my lord. That is again an academic unit,
That is again.
an academic unit.
What do you mean?
I'm an administrative cadre man person.
Lordship,
my lord.
the cadre, I must clarify this, the cadre aspect has just been introduced in CBSE in 2017. So it is not that strictly being followed because there are 70% vacancy in administrative cadre and 16% vacancy in non-administrative cadre. That's why the person from administrative cadre, which has evolved only in 17, they are being put in academic, and he is not just alone. There are various joint secretaries who have been put who are in
22nd.
My lord, I have one small submission, my lord. We do not know what our client will react. We'll definitely convey it, my lord. Supposing he doesn't, so lordship will decide on merit. So therefore, my lord, 24 officers have been transferred from same place. Why I could not be, my lord? That let them produce the record, how they have applied by their mind.
Of what?
My lord, what had happened? Out of the 72, 24
We are
officers.
concerned with 9 officers, joint secretary post.
joint.
No, no, my lord.
Not
There are.
lot of others
No,
and
no,
others. There are so many.
No, 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 my lord. What had happened? In the same station, for example, in Guwahati, there is an office of RO, regional office. He says in the same building, all right, accept it. In the same building also that COE office is there. Similarly, in other places also similar arrangements are there. Now, what they have done in this exercise, 24% has been transferred from same place to same place. Just change of, cadre or something. No, no, what I'm saying is, my lord, when there is a transfer policy, which assures you a tenure of 3 years, if you have to do away with the transfer policy, then you must disclose some reason. So which is that reason? Let them place.
I've explained in my
No,
affidavit.
not explaining your affidavit.
Oh, please.
Record where the decision-making process
Let us see,
has
let
been
us
made.
On 22nd, we'll hear.
Lordship will kindly see, it's a certiorari proceeding. If they do not produce the record, then Lordship will have to draw adverse conclusion.
22nd, yes,
Yes.
certainly, if it is required, so we'll take that.
Yes.
Much ado.
Item 21.
Yes, please, your lordship. Please,
Now, your lordship, may I submit to you? Now, what has happened in this case, your lordship? If your lordship permits me to place the facts, your lordship, in the year 1985, your lordship, husband of the petitioner was appointed, your lordship. Appointed as an assistant teacher, your lordship. In that particular appointment order, there is a condition that he will have to clear the junior basic training in 2 chunks, your lordship. And unless he can complete, your lordship, then services will be terminated. Now, your lordship, in 2 chunks, he could not, your lordship, and ultimately his service in 1988 was terminated, your lordship. He came before this honorable court. Honorable court passed an stay order, your lordship, in that select. But your lordship, that termination order, but your lordship will find, your lordship, that the government did not act on that stay order, your lordship. Now, what has happened, your lordship? If your lordship comes to page 38, your lordship will find a letter by the Joint Director of Elementary Education, page 38. Originally is in vernacular, that is at page 39. The type copy is here, your lordship. It is ordered that those secondary teachers who could not succeed in the basic training course and removed from services and succeeded in the 3rd round are hereby given reappointment as per a criteria set by the government. Now, this was a decision taken by the government, your lordship. And in the meanwhile, I also cleared, your lordship, my junior basic training in the 3rd chance. Your lordship will get it. That your lordship will get it at page 40, your lordship. This is letter, your lordship, 26/10/1989 by the
26/10/89.
Lordship.
So how can you be run benefit of this or this 38 annexure this C?
Lordship, they have already given me benefit, your lordship. Your lordship, in enclosing herewith the application from the Moniram Patil in original, the husband of the petitioner, I am directed to request you kindly to appoint him in any regular post of LP school teacher subject to vacancy as per this office letter number so and so, since the incumbent has passed the junior basic training examination in 3rd chance, your lordship. Now, in pursuance to the policy decision taken by the
Number, which page you are reading?
page, your lordship, 40, your lordship, 40, 38, 39 and 40, your lordship.
89.
89, your lordship.
Original director requests to kindly appoint him on a regular LP subject to the vacancy as per the office letter dated 7 to seeing the incumbent has passed the junior basic exam in 3rd chance.
Now, in terms of the policy decision, your lordship, joint director asked this DI of schools to appoint me, your lordship. And accordingly, DI of school, your lordship, will find in next page, your lordship, he appointed me in 1991, your lordship. Pursuant to an order dated 8/9/989 so-and-so and official communication so-and-so issued by the Joint Director Elementary Education, Sri Moniram Patil, who have been removed from service as stipended, is hereby appointed as an assistant engineer in the scale of pay of so-and-so per month against the vacant post of retired teacher so-and-so, so-and-so. The appointment is purely temporary and can be cancelled at any time without it. Then, Your Lordship, I continued, Your Lordship.
Up to when?
Up to 2013, Your Lordship.
2013.
13, Your Lordship
what
will,
happened?
page 43, Your Lordship may kindly come.
Then what happened?
Then, Your Lordship, he was transferred to some other school.
Fine.
Then he was, Your Lordship, made the head teacher, page 46, that is a
Health teacher.
head teacher, Your Lordship.
What's still going on?
Lordship, that's, as per Your Lordship, that policy decision I was put, not me, Your Lordship, my husband. He in the meanwhile died, Your Lordship, in 2017.
Your assistant teacher appointed as head teacher.
No,
and
after, not,
against the vacant post, temporary basis. Where your, this temporary appointment of your was regularized at any point of time? Purely on temporary.
Your Lordship will come to page 46.
Can be cancelled. 46.
To page 46. Pursuant to the office letter, proposal number so-and-so, block elementary education, and on the basis of medical certificate, service of following teachers who have completed more than 3 years of service are hereby regularized in the post shown against their name as given below.
So now, what was the issue then?
Issue is this, Your Lordship, in 2013, till 2013, I received salary. My husband received salary, Your Lordship.
Okay.
In 2013, Your Lordship, suddenly, Your Lordship, they included his name in the list of illegally appointed teachers, 756 or something.
Certainly, exactly, sahi kiya.
No, Your Lordship,
The appointment, how this appointment was there?
no, Your Lordship will,
There certainly illegal appointment.
no, Your Lordship will kindly see, Your Lordship, these
Then
then, Your Lordship, since 2013, no salary has been paid to the
so
petition.
what your husband was doing at that time?
He was, Your Lordship, retired as a head teacher of that particular school.
When?
He retired in the year, Your Lordship, 2016.
So 2013 till 2016, when no salary was paid,
Paid, Your Lordship.
he has not raised any grievance at any point of time.
Then he came before this honorable court, Your
He
Lordship.
came.
He came, Your Lordship. And during pendency of that particular case, Your Lordship, he died.
Okay.
He came in 2016, Your Lordship.
2013, sir, after he waited for 3 years and then came in the year 2000.
16, Your Lordship. And then when he came, Your Lordship, while Your Lordship, the petition was pending, Your Lordship, the husband of the petitioner died, Your Lordship. The wife substituted, Your Lordship. Then this honorable court passed the impugned judgment, Your Lordship. Now, Your Lordship will kindly see, Your Lordship, there are, Your Lordship, certain communication which, Your Lordship, when his name was, Your Lordship, put, Your Lordship, in the list of illegally appointed.
What about this civil rule number 1344?
That, Your Lordship, in 1993, Your Lordship, that civil rule was, Your Lordship, dismissed for default, Your Lordship.
What was that civil rule? Why you approached this court? That was a
Challenging the
civil rule
termination.
means did petition at that time?
Yes, Your Lordship.
Okay.
Read petition at that
Why,
time.
why you approached this court?
Your Lordship, challenging the initial termination, Your Lordship.
Initial termination of which date?
Your Lordship, 1988, that Your Lordship, you all will get it at page 36. The order.
Thirty-six.
36. This is the order of the honorable court, Your Lordship.
No. 36, where was the termination order?
Termination order was passed on, Your Lordship, 27 June 1988.
Where is that?
That, Your Lordship, that was not part of that. That was not annexed, Your Lordship, in the writ petition.
In which year you were appointed?
1985.
1985, you were appointed.
Appointed.
In
Your Lordship,
1998, your services were terminated.
terminated.
Then
I came before this honorable court along
What
with two
happened?
others.
Then what happened in this court?
This honorable court initially stayed that termination order, Your Lordship.
State that termination order
Order.
of the year 1988.
88, Your Lordship.
Okay, then
Then, Your Lordship, they did not act upon this, Your Lordship. This stay order.
they have not reinstated you.
No, Your Lordship. Then what happened, Your Lordship? In the meantime, they took this policy decision, Your Lordship.
Which policy decision?
That's page 38.
Page 38. Page 38.
Type copy. Original is in vernacular, Your Lordship. That is at page 39.
Yes.
It is ordered
Ordered
that
those suspended teachers who could not succeed in basic removed from the services and succeeded in third term are hereby given reappointment. Okay.
then, Your Lordship, I applied. Since I also, Your Lordship,
First of all, where is your termination order?
termination order, Your Lordship, that was not in the writ petition, Your Lordship.
What was the reason for your termination?
That is, Your
since
Lordship,
you have not completed the basic training.
that I have made, Your
Where
Lordship.
is that?
Basic training he could not pass in this second year.
Where is that termination order, sir?
Termination order, Your Lordship, that was not part of the writ petition.
Why?
That, Your
What was
Lordship,
that termination order? That was the only reason or some other reason was?
that was the only reason, Your
What's
Lordship.
that, sir?
Look,
That's why-
Lordship will
why you are
kindly,
not highlighting
no,
the
Your Lordship
termination
will, Lordship will kindly see in affidavit in opposition filed before the single judge, Your Lordship, honorable single judge, they have not raised, say that, Your Lordship, that any other reason is there for termination.
You just show us. We want to see this.
Lords.
And once your services were terminated, how this reappointment and when this reappointment was given to you?
Your Lordship, in 1991,
In pursuant to the order dated 6/6/89.
Lordship.
1991, you were reappointed.
Lordship.
Under what order, sir?
Your Lordship will kindly see,
Pursuant to the order dated 9/8/89 passed in civil rule number, official communication dated, Joint Director Elementary Education who has removed from stipend teacher is hereby appointed. So pursuant to the interim order passed by this court in 134488.
before that, Your Lordship will kindly,
Just
that is there.
that order was complied with now.
Lordship will kindly see that page 40, Your Lordship.
40.
This is by the director, Your Lordship, elementary education. When they did not comply initially, I filed a petition, Your Lordship. I am in enclosing herewith an application form, see so and so in original. I am directed to request you kindly to appoint him in any regular post of so and so subject to vacancy as per the office letter since the incumbent has passed the junior basic training examination
Fine.
in the third chance.
Fine.
So, Your Lordship, on the basis of this, Your Lordship, in 1991, I was appointed. Your Lordship.
Not on the basis of this, sir, on the basis of this pursuant to the order dated 9/8/89 passed in civil rule petition.
Both is there, Your Lordship.
No, both is not. Where is that both?
That is a hide memo number so and so dated 6/6/86. That is the policy decision.
6/80, and official comment 6/6/86. What is this 6/6/86?
That is that, Your Lordship, page 38, Your Lordship.
89.
This is 89, Your Lordship. There is
89.
Yes, that is typographical error in English version, in original.
English typographical error.
Yes, Your Lordship, page 42, Your Lordship, it is 6/6/89. Page 42. My friend in Education Council may confirm it, Your Lordship. In page 42, while making type
So your appointment was pursuant to this office memorandum
as well as, Your
as
Lordship.
well as the order. Then what happened to that writ
Then,
petition?
Your Lordship, I continued till 2013.
What happened to that writ petition?
That writ petition, Your Lordship, in 1993, Your Lordship, that writ petition was dismissed for default.
Stay also vacated.
Ultimately, Your Lordship, stay was vacated.
Then how this appointment order?
But, Your Lordship, appointment was prior to stay, Your Lordship, and that has been continued, Your Lordship. And that Your Lordship will find in the affidavit in opposition, Your Lordship, they have not taken any such plea, Your Lordship. I have annexed their affidavit in opposition.
What plea?
That, Your Lordship, I was terminated for some other purpose, Your Lordship. They have admitted that I was appointed by the authorities, Your Lordship.
Admits.
You,
In due course.
deeply obliged, Your Lordship.
Item 22.
This concern, same are represented to Court of India.
Deeply obliged, Your Lordship.
Yes.
May please, your lordships. Learned single judge basically, my lord, rewritten the ROP rules of 2017 and interfered with with a communication which was never challenged, read down the rules of 2017, lord, which could not have been done in exercise of power. I'll just take your lordship first with the prayer made in the writ petition. The prayers were page 61. A writ of lordship.
Yes.
A writ of mandamus should not be issued directing the respondents to calculate the pre-revised basic pay of the petitioner since his appointment as private secretary as 19,150, including pay in the pay band of rupees 12,000 plus grade pay of 5,900 and principal seat pay 1,250. Writ of mandamus should not be issued to the respondents directing them to revise the basic pay of the petitioner after his appointment as private secretary on the basis of Assam Service Revised Pay Rules 2017 by calculating the pre-revised basic pay of 19,150 and thereby calculating his revised basic pay as rupees 47,320. Writ of mandamus should not be issued directing the respondents to pay the arrears of the petitioner to the amount remaining unpaid if the petitioner's revised basic pay is calculated as rupees 47,320 since his appointment as private secretary on so and so. So these were the prayers. So he was initially appointed page 64 as page 64 as stenographer grade 2. In the pay scale, pay band of 8,000, 35,000 plus grade pay of 4,300.
Yes.
Thereafter, he got promotion by order dated page 78. To stenographer, sorry, as private secretary. Pay scale is 12,000, 40,000. Page 78.
Yes.
12,000, 40,000 plus grade pay 5,900.
Yes.
Now, in the meantime, my lord, the ROP rule 2017 was notified by Gazette notice.
1/4/2017.
Effect from 1/4/2017, it was notified on 17/3/2017. Gazette notification came. So we have to fix his pay first in the stenographer grade 2, because at that point of time, 1/4/2016, he was stenographer grade 2.
No, this on 23rd of January 2017, he was 1/4/2016. Yeah.
1/4/2016, he was stenographer grade 2.
Yes.
So first we'll have to fix his pay in the rank of stenographer grade 2 on 1/4/2016. Thereafter, by following Rule 11 of the ROP Rule 2017, we'll have to fix his pay in the promoted post of private secretary with effect from 23/1/2017.
Yes.
Rule 11, if I take take your lordships to the Rule 11, lordship will find.
Rule 11.
Yes, it's part of the pleadings, my lord. I have the ROP rule.
Part of the pleading show?
Yes, I'll just show. Page 110.
Yes. Rule 11.
Yes, fixation of pay on promotion on or after 1st April 2016.
Yes.
In case of promotion from one post to a higher post on or after the first day of April 2016, the fixation of pay of a government employee shall be made in the following manner.
Yes.
One increment equal to 3% of the sum of the existing pre-promotion pay in the pay band and grade pay corresponding to the pre-promotion post shall be computed and rounded up to the next multiple 100. So
Multiple
one
of 10.
increment equal,
Multiple of 10.
sorry, multiple of 10 million. I'm sorry. 3% of the existing pre-promotion pay in the pay band and grade pay. It doesn't say about PSP, my lord. B, my lord, clause B in the next page.
Yes.
In case of promotion, revised pay in the pay band shall be fixed by adding the amount arrived at clause A. That is 3% that we have arrived at clause A. Above, clause A above to the existing pre-promotion pay of the employee in the pay band.
Yes.
He will also be given grade pay at enhanced rate as applicable to the promotion post. So whatever his pre-promotion pay, that is my lord pay and grade pay, 3% will be added and his pay will be determined. Now there is a, my lord, para starts from however. This was applied in his case, my lord. If the revised pay so arrived at consequent to promotion becomes lower than the minimum of the higher pay band to which he has been promoted, then his pay shall be fixed at the minimum of the higher pay band. After such fixation, he will automatically move to the higher pay band to which he is promoted and he'll draw pay as applicable to the post which has been promoted. Now, how the fixation has been done in the case of the appellant, sorry, respondent, it was given by the finance department because initially he submitted representation to us. Instead of running a risk, we forwarded it to the, because these all fitment tables and all are provided by the finance, my lord. We don't create anything, my lord. So we followed the finance department. So the finance PRU department, my lord, issued this fixation at page 105.
Yes.
So lower post stenographer grade 2. Now, prior to that, my lord, the principal seat pay has been given, pay band and PSP.
What is this principal seat pay?
My lord, principal seat pay is a special pay given to the employees appointed in the principal seat of the Guwahati High Court. There was a litigation, and pursuant to that litigation, my lord, government, judicial department had issued a notification. That notification also here, I have annexed, my lord. It says that as an interim measure, the principal
Where is that notification?
pay 77, my lord. Milord, I'm sorry, it's not very clear. The page is not very clear, Milord. There'll be some trouble your lordships find in reading.
In compliance of the Honorable High Court.
In compliance of the Honorable High Court order dated so and so, passed in writ petition so and so, as approved by the cabinet in its meeting dated so and so, the Governor of Assam is pleased to approve payment of principal seat pay to the officers and staff of the Guwahati High Court principal seat as an interim measure. Lordship will mark this as follows. The officers and staff of Guwahati High Court principal seat will be paid principal seat pay in addition to their existing emoluments, existing pay and allowances on the following scale. Lord, pay band 1, 500, pay band 2, 750. Then if an employee is in pay band 3, he'll get 100,000 and pay band 4, 1250. Principal seat pay shall be admissible to the officers and the staff of the principal seat of the Guwahati High Court in addition to their respective pay in the pay band and grade pay. So this is an additional thing apart from pay and grade pay, my lord. For determining basic pay, that is basic pay is equal to pay in the pay band plus grade pay plus PSP. So in view of this notification,
This PSP
PSP,
was.
yes, PSP
introduced.
was granted as an interim measure and it is in addition to pay and the grade pay. So it will not form part of the pay revision in principal secretary, my lord. So what they have done, my lord, the finance department, page 105.
Yes.
Lordship will kindly see, as per rule 11 of the Assam Service ROP Rule 2017, read with FR 22-1A1, the fixation was done. Lower post stenographer grade 2, pay structure for the post PB3, 22,000, 97,000 plus grade pay 9,400 in stenographer. Date of release on 23/1/2017. Last pay drawn 38,640. Now this 38,640, your lordship will find how it came to 38,640 at page 109. This is fixation of initial pay. This is the manner in which all the more 800 plus employees of the Guwahati High Court, the initial pay fixation was done. Similar in all respect, my lord. Now, date from which revised pay scale is applicable 1/1/4/2016. Existing pay structure PB3 8,000 to 35,000 with grade pay 4,300. This is stenographer grade 2. Basic pay in the pre-revised structure on the date from which revised pay is applicable comes to 14,550. Lordship's got. It includes PB, grade pay and PSP. Now pay in the revised pay scale 27,110, grade pay 9,400 and PSP 1,000. Total revised basic pay came to 37,510. As on 1/7/2016, his pay is 37,510 plus 1,130. That is the next increment he got. And it came to 38,640 on 1/7/2016. That is on the date of next increment. 1/4/2016, his pay was 37,510. He got one increment on 1/7/2016, 3%, and his pay on 1/7/2016 came down to 38,640.
But in that you have added the PSP.
That PSP will come, my lord, because it's part of his pay. While fixing at the in the rank of stenographer grade 2, that PSP will include it. I'll just clarify that, my lord. Lordship has raised. Now is 38,640. Now we come to the higher post page 105. Your lordship will kindly come. Stenographer grade 1.
Yes.
Now pay structure is 30,000, 1,10,000, grade pay is 13,300. Fixation of pay in the higher post on so and so. Last pay drawn in the lower post is 38,640.
Right.
Now, one increment 3% of 38,640. It should have been, my lord, there is typographical error in the typing. It's not 36,410, it should have been 38,640, my lord. 3% of 38,640 comes to 1160.
So it's not 410.
3641, it's not 36,410, my lord.
38,640.
38,640.
38,640. Yeah,
So it total comes to 39,800.
yeah.
Then we'll have to give him the new grade pay and new PSP as per rule 11. So we have deleted the old grade pay and old PSP. Then his total come to 29,400. So we gave him the new grade pay, new PSP. Milord, there is another typographical mistake before the last PSP. This should not have been minus. This was plus. Column 8. I'm sorry, I'm extremely sorry. It was in fact added.
In the ultimate calculation, it is added.
Yes, Milord, Lordship will kindly check 29,400 plus 13,300 plus 1250. It comes to 49,900. I have checked, Milord.
43,940.
43,950. I have checked, Milord.
Fine.
Now the amount arrived at is found to be less than the minimum of pay, sum of pay in the pay band 30,000, 1,10,000, grade pay 13,300 and PSP 1250. Milord, whether we include PSP or doesn't include PSP here, minimum of pay means 30,000 plus grade pay 43,300 plus PSP 44,500. As such, the pay of Sri so-and-so is to be fixed at 44,500. That is 30,000 pay, 13,300 GP and PSP 1250 with the date of next increment on 1700. So that is the, however, we read, Milord, in the rule that a paragraph starts with however, that however, if the pay is found to be less than the minimum of the pay band, then, my lord, his pay is to be raised to that level. So in our fixation, it came down to, my lord, 43,950, which is less than 44,550. So we fixed, we raised the pay to 44,550. Now, there was an RTI application filed by the respondent to the registry. In that RTI reply, he asked for that on the date of promotion, what was his basic pay? So his basic pay was shown as 19,150. Now, taking 8 of that, my lord, taking 8 of that, he tried to project the case that his fixation has to be made on that 19,150.
Not on this.
Not on, basically what he is trying to say, whatever you do in stenographer grade 2, I don't know. But my basic pay as per your RTI reply was 19,150. You have to fix that 19,150 directly in the fitment table 1.22 and my equivalent pay, revised pay has to be determined. Milord, with all due respect, Milord, rule 11 is absolutely clear. Milord, going by rule 11, first your pay in the stenographer grade 2 has to be determined, refixed. Then the promotion post of stenographer, Milord, private secretary. We cannot do 19,150 on 23/1/2017, Milord.
Yes.
Learned single judge in the impugn order has upheld that contention, interpreting the minimum of the higher pay band to be pay, grade pay, and PSP, which is absolutely wrong because of the fact that there is no separate fitment table for Guwahati High Court employees, Milord. We follow the fitment table provided by the ROP Rule 2017, which is for all. In that fitment table, Milord, there is no PSP column. So we'll have to take pay and grade pay. That pay and grade pay total amount has to be revised by applying the fitment table. Thereafter, my lord, the PSP will be added. 1250. Learned single judge had found fault with that aspect, my lord, and interfere with this fixation, page 105, read down the rules of ROP rules 2017 and derived conclusion that we'll have to make the fixation on the basis of 19150, my lord. In my humble submission, my lord, that is there is error, absolutely error.
Is that relevant para?
Yes, relevant paragraph, I'm just placing, my lord. Lordship will find para 14, page 139, my lord.
Yes.
However, by applying the formula of basic pay equal to PB plus grade pay plus PSP, the minimum basic pay in the pre-revised stage in respect of a private secretary stenographer grade 1 in the principal seat of the Guwahati High Court would be rupees 12,000 plus 5,900 plus 1250, which is equal to 19, my lord, this is typographical error. This is not 19,500, this is 19,150, my lord. Without the PSP being added, same would have been PB plus grade pay, that is 12,000 plus 5,900, which is equal to 17,900. As such, as provided in the formula contained in the notification dated 16/8/2016, basic pay of an employee of the principal seat of the Guwahati High Court would also have to include the component of PSP, and the minimum basic pay of such employee would not be same as the minimum basic pay of any other category of employee, and the figure that may be arrived upon adding the PSP to PB and GP would be the minimum of the basic pay. Accordingly, the minimum of the basic pay in the pre-revised pay structure cannot be 17,900, which is without adding the PSP, and the minimum of the basic pay would have to be 19,150 by adding the PSP. The applicability of the minimum basic pay upon revision cannot be the fitment equivalent of rupees 17,900, whereas it has to be equivalent to the fitment of rupees 19,150, which would be as per serial number 4 of table number 1.22. Accordingly, it would be the revised pay corresponding to the fitment 19,150, which as per serial number 4 of the table number 1.22 would be 19,570, and thereafter the corresponding total pay in the revised pay structure would be rupees 47,320, which would include the PB of rupees 34,020. In other words, when the pre-revised pay structure had provided for minimum basic pay of rupees 19,150 for the private secretary of the principal seat of Guwahati High Court, the minimum basic pay in the revised pay structure cannot be less than the equivalent of the fitment corresponding to rupees 19,150 in the pre-revised pay structure. Now, my lord, para 15. On the contrary, if we accept the view expressed by the finance department and the authorities in the Guwahati High Court to be correct, the resultant situation would be that the minimum basic pay of a private secretary's stenographer grade 1 upon revision would be 43,300, which would comprise PB 30,000, 1,10,000 with grade pay of 13,300. If the minimum basic pay is 43,300, which contain PB so and so with grade pay 13,300, as accepted by the respondents in the finance department and the Guwahati High Court in presenting their calculation as per the communication dated so and so. Conversely, it would be accepted that the minimum basic pay of a private secretary stenographer grade 1 in the pre-revised pay structure was 17,900. But as already discussed above, the said figure firstly does not include the PSP, and upon inclusion of the PSP as per the formula that basic pay is equal to pay in the payment plus grade pay plus PSP, the minimum basic pay would have to be 19,150, which is factually correct and in fact was paid to the petitioner prior to giving effect to the revision of pay. As the view of the finance department and respondents in the Guwahati High Court is that the minimum of the higher pay band upon revision of pay to be 43,300, comprising of PB 30,000, 1,10,000 with grade pay of 13,300. the same would be inconsistent and incongruent to the corresponding minimum basic pay paid to the private secretary stenographer grade 1 of the principal seat of the Guwahati High Court in the pre-revised pay structure. The corresponding minimum basic pay to the revised pay of rupees 43,300 in the pre-revised pay structure would be 17,900. But by adopting the formula basic pay is equal to PB plus GP plus PSP, the minimum basic pay cannot be less than 19,150. Therefore, the minimum basic pay in the pre-revised pay structure would have to 19,570. Corresponding to
Yes, Lordship. This ROP rules is specifically for the state government employees. But yes, High Court employees has PSP included in their basic pay.
For the interim measure, as an interim measure, with the direction given by this court. But ultimately, the
Yes,
pays
Lordship.
are to be fixed as per the ROP rules.
Lordship, if we see what was his basic prior to the revision of the pay.
Yes.
Basic, he was getting 19,150.
Yes.
12,000, his, then pay band 5,900, then PSP, he was getting 1,250. So his basic pay before revision was 19,150. So accordingly, the fitment will be as per what was held by the learned, by the Honorable Single Judge, Lordship, which we have, and which PSP cannot be, PSP is part of the basic, Lordship, which is also part of the basic. Even in the RTI reply, RTI reply, Lordship, which petitioner has received, it says that what is the basic pay in page number 97, Lordship.
Yes.
So 97, the query is the pay scale of a stenographer grade 1 of this Honorable High Court before 7th pay commission and after implementation of the PSP is, first is 12,000. So he was promoted in the year 2017. So 12,000 plus the grade pay 5,900 plus PSP 1,250. So PSP is added in the Lordship. PSP is added in the basic pay. So basic pay, his before revision was 19,150. So his basic cannot be reduced down while fixing his pay revised scale, Lordship.
See, we'll hear this matter, okay?
Lordship, which is very clear in the RTI and which is also learned
Have you
single.
filed any counter to the appeal?
No, this came for the first time, Lordship. I have not filed it.
Yeah, issue notice. It's so put an appearance on behalf of the respondent number
1, Lordship.
Respondent number 1. What about the others respondents?
other finance LR Finance and AG.
Yes,
I again on the phone.
or for AG. And who is appealing for this additional, which is that another?
Finance.
State of Assam through legal determination, who is this?
Government, has to be by the government, my lord. LR.
So who is appearing? Likhe, Ms. So-and-so put the issue notice. Mr. So-and-so is appearing on behalf of the respondent number 1. Mr. So-and-so is appearing on behalf of the respondent number 2 and 3. Mr. So-and-so is appearing on behalf of the respondent number 4. Services therefore complete. Admit. See the admit so-and-so. The respondents may file their counter affidavit to the writ petition if they desire so within a period of 4 weeks. In due course.
Lord, I have,
Deeply obliged, Lordship.
there is an I praying for stay of the impugned order, my lord.
Yes.
Then I'll file objection, Lordship. Thereafter it can be heard. Because this was not actually appeal. was-
Issue notice, so-and-so accept notice on behalf of the. In the meantime, effect and operation of the order impugned shall remain stayed till next date. However, the respondents are free to move application for vacation of the vacation of this interim stay order along with the counter affidavit along with the affidavit in opposition filed to this writ appeal.
Well.
You are free to move an application for vacating this.
Item 25. Highly objective. Deeply objective. Item 25.
25.
Yes, I am
Yeah.
the
Petitioner one.
Yes.
Lordship would like to fix a date so that when it's PI,
What do you want?
date,
No.
Which date?
whether 3rd or 5th of September.
You just ask the court master of your convenient date, he'll give it.
I was saying prayer for supply 51 Malo. It is listed on our prayer Malo.
Which one?
Item 51 Malo. It listed on our prayer. Some urgencies there.
50 onwards,
51 Malo, supply Malo.
supplementary.
Yes,
51.
Malo. It is by order. It is
This 51.
51. Lordship may take about 2 more, some.
Day after tomorrow, laga dena. Day after tomorrow.
Your Lordship, I would like to mention item number
December
46 to 49.
46 to 49.
Your Lordship, on the last occasion on 6th, we have fully heard is the issue of 14A disallowance. On the basis of explanation added by the Finance Act, whether it is prospective or retrospective. Incidentally, I was not carrying the order in the miscellaneous petition. And I was totally heard, the other side was also present. And I was called today to just place that miscellaneous order, how tribunals are dealt.
In fact, I have not recalled that.
Your
order.
Lordship, can I have it tomorrow, have the?
Tomorrow,
I am coming from Calcutta, I will stay back.
So tomorrow it may not be possible because tomorrow we have some hearing matters already. Then in the next week,
As your Lordship,
29th,
any day, your Lordship.
29th of August.
Can it be at the higher level? I am coming from out.
Sir, if it's a hearing matter, we can't change this situation.
Oblige, your Lordship.
May I also take the liberty, Madam? Item 32,
32, yeah.
can it be fixed on 30th?
30th, your lordship, I have difficulty and we have some urgency also, your lordship. Ultimately, your lordship, press tender has been issued, your lordship. My, if that is settled, your lordship, my case automatically become infracted.
Item number 30.
32, your lordship.
32.
Lords.
So now what do you want?
I was praying for 30th of August.
And what he's saying, yes,
Lordship, my prayer is, would have been, your lordship, to fix it on 21 on 22nd, your lordship.
22nd,
Lordship.
this week.
This week, your.
Please don't do this.
Then your lordship, 28, your lordship.
28th.
Oblige.